My lord. Lord, I am praying for leave to move the application, my lord. Urgent application on Monday, my lord.
Monday.
Monday, my lord. Let it appear as to be mentioned, my lord. Very urgent, my lord.
Your Lordship, thank you.
Right.
Forget to mention one matter, Lordship. Recent criminal application, Lordship, of 2018. Your Lordship was hearing this matter when Your Lordship was taking up the criminal matters. Pursuant to which, Your Lordship has heard it number of times. By the order dated 7th February 2023, Lordship, Your Lordship has fixed this matter as part heard. After that, the matter went out of place. Now, recently, the parties to this application have filed a joint compromise application. And they have entered into a. I'm only praying for
Proceed.
in the list, Lordship, as to be mentioned.
I don't have the determination.
Your
Criminal
Lordship,
matters.
Your Lordship has made it part heard. Your Lordship has
I made it
the-
Potter.
Lordship
When it was made Potter?
is 7th February 2023, Lordship.
2023.
Lordship, after that, the matter went out of place for a considerable amount of time. Only Your Lordship can take
It
up
was
this.
not disposed of.
No, Lordship, not yet. The parties have recently entered into an amicable settlement, Lordship, pursuant to which we have already filed our joint compromise application.
Very good.
So, Lordship, kindly take it up as to be mentioned, this matter can be disposed of. We have already filed our application.
Which date we mentioned?
Tuesday to be mentioned. Extremely grateful, Lordship. Extremely.
Subject to the fact that record has to be reached. Otherwise, it is not possible. Yes, Mr. Mukherjee.
He is appearing in item number 1 by the leading.
Okay. Call item number 1.
I'm appearing for the petitioner along with the submitter and other learned advocates physically present before Lordship.
Yes.
Lord, I appear for the respondents.
You are appearing for the respondents.
Respondents, KMD.
KMD.
Yes, I think KMD is. Well, Lord, before my learned senior friend, my Lord, places on merit.
Now, already we have started the argument. They have already started the argument.
No, it not
Yes,
start.
last occasion, argument has already started.
The matter, the prelude was given.
On 15th
This
May,
is-
my lord,
Yes, 15th
This
May.
is, yes.
So, what you
Lord-
want to say?
My Lord, the maintainability of this writ petition, I have taken initially, that was kept on record, kept open. My Lord, that point may be hard.
Kindly argue that point first. Maintainability is decided first. Below maintainability of the matter,
Yes,
below is to be decided first.
If you Lordship,
then you have to argue first.
I will have to argue on this maintainability issue.
Very well, you start.
Yes. My Lord, here
Yes,
the subject matter of challenge is, Lordship, for a moment, if I show to your Lordship, page 91.
page 91 of the writ petition.
Yes. Oh, sorry.
Mark karo. Page 91.
91. My Lord, this is, Lordship,
Yes, got it.
Lordship got it. It's a demand raised by the KMC. The description of the demand, Lordship, will find the KMD's development charge. The second line, my Lord, I am not reading, that is not relevant to. The KMD's development charge. After sanction, it will appear from the writ petition that after they have paid the sanction fee and all of the charges, and thereafter the KMC raised this demand. They were aggrieved by this, and they have secured this amount towards the KMD's development charges by furnishing a bank guarantee. That is, of course, my Lord, the next page, Lordship will find the bank guarantee. Later on, they came to the Honorable Court, challenging that such development charges they have already paid. So they are not required to pay any more development charges.
Okay.
My Lord, the writ petition was heard. My Lord, we appeared. Because in the meanwhile, the KMC wrote us that kindly apprise us whether this development charge is leviable. That KMC wrote us. My lord, we apprise the Honorable Court that we have received a request from the KMC. We are yet to take decision on this issue. The writ petition was disposed of, my lord, with the direction upon the KMDA to take a decision on this issue,
Whether it is leviable or not.
whether that is leviable or not. My lord, pursuant to that order, the KMDA started the process. Hearing notice was given to the petitioner. My lord, initially they, by filing a writ petition in 2020, that is WP number 89 of 2020, 103. Just a minute. My lord, here, my lord, I stand corrected, my lord. My lord, the first writ petition was, my lord, against the subject matter was there. The KMC, the bank guarantee which was furnished by the petitioner in favor of the KMC sought to invoke that bank guarantee. There they were aggrieved and came to the Honorable Court. And the second writ petition they have filed, which is number WPA number 8107 of 2020. There, my lord, we have started the process. It was the grievance of the petitioner that they were not furnished, they were not apprised of the factual and legal basis of such development charges. Lordship will find, if your Lordship takes up the two orders, if your Lordship takes up my affidavit in opposition, I have annexed the orders, my lord, wherefrom I place this. Page 100 of my opposition. This was the second writ petition of the petition. Sorry.
Yes, page 100.
Page 100. Lordship will find the second paragraph, the grievance has been put
WPA
here.
8107 of 2020.
Yes. The grievance of the petitioner is that despite a specific order of this court directing the KMDA to decide as to whether any development charge as per demand notice is to be paid by the petitioner, KMDA is not clarifying the basis of such claim to enable the petitioner to respond. Here, my lord, pursuant to the notice issued to them to attend a hearing, they attended the hearing.
3rd November.
3rd month.
Petitioner.
Yes. They attended the hearing, submitted representation, asking for the basis. Here, this writ petition was disposed of. If your Lordship turns to the next page, the last paragraph, Lordship will find the direction. In such view of the matter, WPA number 8107 of 2020 is disposed of by directing the KMDA to immediately disclose to the petitioner as to what are the legal, effectual and legal basis for imposition of such development charges, which are in question. The basis of calculation of the quantum of such charges, if leviable, and the legal basis of such claim for development charges. Such disclosure shall be made in writing on behalf of the KMDA and communicated to the petitioner within a week. The KMDA will fix further date or dates for hearing within 10 days from such communication. Here, my lord, this line is very important for me on this issue. The KMDA will fix further date or dates for hearing within 10 days from such communication. So this was the direction And this proceeding was initiated, my lord, by the senior law officer of KMDA. They have not questioned the authority of senior law officer. This order was never appealed against. Here, while directing the KMDA to disclose the factual and legal basis, it was also directed to fix further date or dates for hearing within 10 days. So court in a way allowed the authority to proceed with the proceeding, but before that to disclose the legal and factual and legal basis. This was the direction, my lord. Pursuant to this, if you should next turn to page 103. In compliance of this order,
Yes.
the senior law officer KMDA disclosed the legal and factual basis in writing what was directed upon. I am not placing the entire, my lord. This is on matter of record, my lord. Then, my lord, Lordship has found
Yes.
103 to 106 are the basis disclosed by KMDA with reasons. Then again the petitioner filed another writ petition. The
This
next
writ
page-
petition.
Yes,
This
this
writ
petitioner. 107. 9560 of 20. Lordship will find the order at page 108. 107 is a small order.
Yes.
Here, now the petitioner takes this point. Lordship will is small order. At the instance of the learned counsel appearing for the respondent number 1 and 2, the hearing of the application is so and so. I'm skipping over. It is further submitted that the learned counsel appearing for the respondent number so and so shall not proceed with the respondent number 2. Respondent number 2 is the senior law officer, Miller, before whom the proceeding was being continued. The respondent number 2 shall not proceed with the hearing in terms of the order dated 3rd November, that is at which are just now shown to your lordship, till the next date of hearing of the writ petition. Then another order lordship will find, this is dated 5th February on this writ petition at 110. The operative part lordship turns to the next page 111, clause 8 and 9. As an interim measure, the demand notice dated 24th October 2016 will not be given effect to. 2016 is Milord 91 of the writ petition, which has shown to your lordship. Very close. I am further told that the senior law officer is in session of the matter, a session of a hearing to decide the justifiability of development charge demanded by KMDA in terms of the notice dated October 24, 2016. Mr. Talukdar says that the said hearing is taking place pursuant to an earlier order of this court in a previous writ petition. Mr. Mitra says that there is no such order. In any event, the senior law officer of KMDA does not have the authority to conduct such proceeding. Be that as it may, since the same issue is now before this court, it will be appropriate if the proceeding before the senior law officer remains stayed until further order. This is the stay order. My lord has seen, I have shown the order, earlier order, the order passed in the earlier writ petition. There, the KMDA was permitted to proceed, fix it for the date. What was submitted by me on that day? Below the stay was granted. There, then below affidavits was directed. Pursuant to that, affidavits were also exchanged. Pending hearing of this writ petition, this present writ petition was filed. Again, another writ petition, that is the present writ petition filed by the petitioner on the same cause of action. I raise this point. The two writ petition on the same cause of action cannot be met. That was heard, and ultimately the petitioner withdrawn this writ petition, that is 9560. That was withdrawn.
Yes.
That was withdrawn. And the interim order, as in the earlier writ petition, there was an interim order that was reimposed in this writ petition, and affidavits were directed. And affidavits are exchanged in this matter. The matter is now. Lordship will find at page 120, the earlier writ petition was withdrawn, and this present writ petition was allowed to continue.
So what is your point?
My Lordship, now page 122, Lordship will find the maintainability point was kept up. Here, if your Lordship in this writ petition, it is not the issue that the KMDA, particularly the senior law officer, who was directed to decide the issue whether the development charge is leviable or not, pursuant to which the KMDA had proceeded.
So what is the point of maintainability?
That decision is yet to be taken by the authority.
Yes, I understand. But the issue is that one order has been passed and again reimposed. You have not preferred any appeal against that order.
That is the stay of the proceeding.
Stay of the proceeding initiated by the senior law officer.
Senior law officer.
So one order has been passed. This is the only point of maintainability you raise or anything?
Well, this is the only point.
So
Well,
how
my
can it
my
be raised?
my point is, below, that the KMDA had proceeded pursuant in compliance of the order passed by this honorable court.
Whatever may be, an
Yeah.
order was passed on that point. An
But-
order was passed. Interim order may be.
That is interim measure.
Whatever may be, that is the interim order. You have not preferred any appeal against the interim order.
Interim order,
So
that is
Now that interim order can be heard by this court in point of maintainability. It can be there. We are starting hearing. Let the matter be heard.
my lord, here, even if the senior law officer is not authorized,
No, you
There-
can
there-
say so. You have the submission, but the order has been passed by this court. And it was reimposed. So now this order cannot be revived by this court because it would be appeal against the order of this court.
I'm not on revival. I'm on this, my lord, that when the KMDA was directed to,
I understand
decision.
KMDA was directed by a coordinate bench of this court to
yes,
first apprise the petitioner what are the grounds for raising such huge amount of development charge, and secondly, after giving that, within 10 days, you give a special hearing to them.
Yes.
This is the direction.
yes,
Your senior officer has apprised by written letter to them
yes,
that these are the grounds.
yes,
They have challenged that point.
Yes.
Okay. So now you have raised this issue before the coordinate bench, and coordinate bench has passed an interim order on that point, directing the senior officer, you please not proceed. This is the situation.
this is the situation.
So this order is now subsisting.
My lord, now subsisting, what I am on,
So if you
that
now,
there
if you
is,
now raise this point again, how the senior officer or senior law officer of the KMDA can be debarred for making hearing like that by virtue of that order, that has already been stayed by this court. If I going to touch the point, it would be touching appeal point by this court. You understand the situation?
yes, that I am on that, my lord, if the court, ultimately, my lord, here maybe the interim order was reimposed in this.
Yes, reimposed. That is the
Writ
situation, reimposed.
But the earlier order by which the KMDA was directed to disclose the factual and legal basis, and the senior law officer was, my lord, allowed to continue with the process, proceeding, that order was not appealed against by them.
Very well. That order
That-
was
that-
not appealed against, but one interim order was passed by this
That
court.
that is for the time being stay his hands.
That's the issue. That's why I cannot touch your merit, your argument. You understand the issue?
Whether this order, my lord, passed in the earlier writ petition will stand in the way. Because there is no decision of the KMDA, which is the subject matter of challenge.
You
in
cannot
this
take
repetition.
decision because there is an order of stay. You cannot take decision unless and until you set aside the order of interim order. You cannot take decision. This is the law. You have to prefer appeal against that. You have not preferred.
Admittedly, we have
So
not preferred.
you cannot touch it because there is an interim order. This court also not touch it because this is the order passed by this court.
This is in this writ petition, assume.
Yes.
But the order passed in the earlier writ petition. I am on that.
So you have to prefer an appeal against the interim order, stating that earlier order was there. This bench has passed the order, flouting the earlier order.
Whether my inaction, my lord, I am subject to correction. my lord.
Okay.
Whether my inaction will dilute my rights.
No, your right is always there. It can be revived by disposing of this writ petition.
Whether the 3rd November order will stand in their way or not.
Yes, stand in the way because of the interim order.
No, 3rd
You
November,
cannot proceed.
3rd November order is in my favor. That was passed in earlier writ petition, not
Yes,
in the,
I understand, but
No,
you-
not-
whether you can proceed,
my,
I can ask
earlier,
you,
earlier means
whether you can proceed now, you cannot proceed because of that interim order.
because of the, I have not proceeded also.
That's
But-
the reason why you
But
are raising this
reimpose,
point.
reimpose the interim order which was reimposed, that is 9560. I am not talking about that order, that writ petition. I am talking about the earlier one, that is 8107.
I understand the issue, whether you can proceed. You can proceed, whether the senior officer of the KMDA can proceed to hear the matter.
No.
Cannot.
Success.
Because of that, the interim
The
order. is
interim
there.
order is
So
there.
why you are raising this point?
I am raising to cut short this matter, whether there is any decision to challenge in this writ petition.
Let them apprise this court.
Yes,
What is the merit?
KMDA is yet to take decision. The KMDA, which was allowed by in earlier writ petition, and subsequently the KMDA was prevented for the time being. The earlier order was not challenged by them. 8107, the order passed.
It is the merit of their writ petition. Let them start first. Okay.
Huh?
Let them start first.
Let them.
Okay, please take down. Learned counsel appearing on behalf of the KMDA raise a point of maintainability of the instant writ petition. Having heard the learned counsel, Mr. Talukdar, on behalf of the KMDA, it appears that the point of maintainability cannot be heard without hearing the entire merit of this matter. Accordingly, the petitioner is directed to start the argument.
Can you pick up
Yes,
notes what we had submitted to our lordship on the last occasion? It's lying with the brief.
notes to them.
They'll give it now, my lord, it was not.
Notes is there. Okay.
Mitra, it was not handed over.
It's being handed over, sir. I have handed it over.
Okay.
Well, I have to place the notes, place all the facts.
Yes.
No.
কি হচ্ছে আস্তে কি করে বসলাম রে
মস্করা করছি
corporation के against principle আপনি তো এই যে bound by the law.
kindly stand the notes below that we have the notes for your lordship's convenience. It
Yes.
will not be necessary to hunt for facts here and there. The challenge is made against leviability of development charges under the West Bengal Town and County Planning and Development Act by the Kolkata Metropolitan Development Authority. Herein may refer to KMD, Kolkata Municipal Corporation, herein after referred as KMC, against the petition, investor J.W. Marriott Hotel. Now, my lord, property tax we pay, but development of the property we are required to pay substantial amount, huge amount.
Okay.
Leviability, the legality of the imposition is on the challenge, not the amount, not the assessment. Can you do it or not? The expression used is leviability. What we are saying now, that we have been waiting for long. Whatever may be your decision, you have the right to impose it. Leviability, the expression is leviability. You can decide whatever you like. You can impose it upon us. Now, my lord, kindly turn. Next paragraph. Challenge is also against the purpose of development charges contains a notice dated October 24, 2016, issued the Calcutta Municipal Corporation for 3 crores 19 lakhs 77,850. This is actual last imposition made against us. Last imposition.
Yes.
Admittedly pursuant to a process of competitive bidding, the KMDA granted release of subject plot by registered indenture of September 28, 2007. The term of 99 years, renewable for a further life period. Now this requires explanation. The property belongs, the land belongs to KMDA. KMDA wanted to develop the area
Yes.
by establishing a 5-story hotel. Open bid. After consideration of the bid, my clients, they were found to be best and they were granted lease for 99 years, renewable.
Renewable lease.
Renewable.
Yes.
Who is the owner of the property? KMT.
Yes.
The lessee, I am the lessee. I am given the property not to develop it in any way I like. I am given the property only for the purpose of establishing a hotel. 5-star. Kindly remember, my lord, usually a lessee is given the right to enjoy the property. That's the definition of section of lease under section 105 of the Transport Code. No, I'm given a lease, no doubt, but a limited right. Right is you have to develop and establish and develop a hotel 5-star hotel. That is the purpose. I can't establish anything else. A residential building, a residential apartment building, nothing to that. Only a hotel. Now kindly turn thereafter. Kindly remember, my lord, we have used the expression owner.
Yes.
I'm not the owner.
You are the lessee.
Lessee, yes. Even a perpetual lessee is not the owner.
Yes.
He is a lessee. The ownership remains with the lessor.
Yes.
Kindly turn. As will appear from the lease deed, particularly clause 2C of the petition, the purpose, and I am not going into the details of different clauses. It is set out here. Otherwise, it will take a long time. What was the purpose? The purpose and use of the lease was strictly defined, and the petition number 1 was, barring change in law prohibiting such purpose, bound to construct and functionalize the project according to nature and mode fixed for the game. KMDA was interested in developing that area. This is near Miller. I don't know, you might have visited. I have not. It's near about ITC. After ITC Miller on Eastern Bypass, Lordship might have seen ITC. Eastern Bypass.
Yes.
Miller ITC Hotel, Science City, in front of the Science City ITC. Thereafter, Miller, sometimes this hotel has been established. That about the area within the subject project is situated also in the eastern fringe of Kolkata, regarding which there is a finally published Land Use Development Control Act on 1979. Paragraph 9 of that. Well, under the Town and Country Planning Act, LUDCP is published. In respect of this area, there is no publication of LUDCP.
LUDCP.
Yes, Land Use Development Control Act.
Okay.
No
Plan.
plan. This apart, the area within which the subject, there is no LUDCP. When there is no LUDCP, no question of development charges. That's one of our points I'm taking later on. But they can possible. Paragraph 6. However, by playing tricks, the KMC during sanction of the building plan realized from the petitioner surcharge plus development. Kindly turn to it below, page 80. Page 81. 80. 80.
Page 80.
Yes, 80.
So the typed copy is the next page 81. Munir.
Kindly turn to page 81.
Surcharge plus development fee.
6. Drainage. Surcharge plus development fee. Era 2. Item number 2.
Yes.
That day post. My
Four
client
flat. 74,000. 400.
no, my lord, it's not 74. The amount is like corporate.
Crore, 4 crore.
Yes.
4 crore 7,74,454.
I paid development, they collected development charge from me at the time of sanctioning the bill.
Okay.
Who is doing it? KMC. Nobody is claiming that KMC is entitled to do it. KMC collected 4 crores.
Yes.
Now we go back.
12 July 2008.
12 July 2008.
Yes.
Kindly come to the next paragraph. At that time, the petitioner was not aware. As I said, surcharge plus development fee is actually being collected with the KMC under the 1979 Act. KMC has no role to play under the 79 Act. Calcutta Municipal Corporation Act, KMC is authority.
Yes.
Town and Country Planning Act, KMDA is authority. But the KMC at the time of sanctioning the building plan collected 4 crores for development. We paid. We didn't notice, my lord. Then paragraph 7. We are not aware. The petitioner came to know from the affidavit in opposition of the writ petition. This the petitioner came to know from the affidavit in opposition. They have disclosed that the 4 crores have been collected as development charge.
Okay.
KMC is collecting. KMC has no role to play under the Town and Country Planning Act. It is the KMDA.
KMD is the authority.
It is not collected by KMDA. It is collected by KMC.
KMC.
In fact, drawing inspiration from the said affidavit of opposition of KMD, the petitioner inquired and found a copy of the approved schedule of fees and charges of the building department of the financial year 2008-9 as approved under section 131(3) of the Kolkata Municipal Corporation Act 1980. Table 4 and Table 5 paragraph reveal that the surcharge including development as collected by KMC is under 1979. They were merely agents. They were merely acting as agents. KMD is entitled to collect it under 79 Act, Town and Country Planning Act. KMC, while sanctioning the building plan under KMC Act, is they collecting the development. unpaid.
Okay.
Despite the aforesaid, the KMC had deemed the pendency of the petition number 1 application for completion certificate for the project raised demand notice of 3 crore 19 lakhs towards KMD's development charge. Therefore, at the time of sanctioning of the building plan, 4 crore has been collected by KMC. That is leviable only under the town and country plan. And at the time of completion certificate, they are again claiming 3 crores. We have paid it by way of bank guarantee, not paid without, we have furnished bank
Bank
guarantee.
guarantee was paid. Bank guarantee was submitted.
Petitioner was almost compelled to secure said illegal bank demand towards the Canadian development charges made by the KMC and furnishing a bank guarantee in favor of the KMC on October 24, 2016. This has been renewed from time to time without prejudice to the petitioner's rights and conditions. Despite assuring petitioner a letter dated August 31, 2018, paragraph at 96 of the decision, the issue of leviability of development charge by the KMC would be heard in presence of the petitioner. No hearing was given. We furnished the bank guarantee and then agreed to participate in the hearing. It was given by the KMC and bank guarantee was sought to invoke by the KMC. Petitioner filed writ petition number 89 of 2020 and obtained interim order on February 5, 2020. Final order at annexation of the writ petition. Petitioner, despite several requests, was not provided factual and legal basis of development. Hence, the petitioner filed WPA number 8107 of 2020, obtained order of disclosure. My land friend was pointing out this. My land friend was pointing out, my lord.
Yes.
Order of disclosure is 3rd November 2020. Paragraph 15. By later dated November 5, the KMD disclosed alleged illegal basis and part factual basis of the so-called development charge. Lord, your lordship, please look at page 112, 950. Kindly turn, my lord. Page 112. Kindly turn to page 112, my lord. What has been disclosed by the KMD? The Honorable High Court
Page 112.
Yes. The Honorable High Court, by order dated 3rd November 2020,
Yes.
passed in WPA number 8107 of 2020, has directed the KMD to disclose to the petitioners what are the factual and legal basis for imposition of the development charges which are in question.
Yes.
The basis of the development of the calculation of the quantum such charge is leviable and the legal basis of such thing for development. We are not disputing the amount. We are disputing the basis of these charges. Can you levy it? What is the legal basis? How to do it? We are dragging this matter out since then. My friend's objection is the matter is pending there. Now we are saying you have no jurisdiction to impose it. Now we have questioned it, really furnished it, kindly turn. Such disclosure shall be made by writing in behalf of KMDA and the communication to the petitioner within a week from this date. The KMDA will fix the dates for hearing within 10 days from such communication on the question whether development charges are to be imposed on the petitioner as directed by order. Kindly turn next page. These three questions shall address your queries as is in your written statement and representation. Item. With regard to point number 1, undersigned on behalf of the KMDA brings to your notice that KMDA has advertised in various newspapers on February 2006 notice inviting offer for setting up a five-star hotel. It was mentioned therein that KMDA wants the project to be developed as a renowned group hotel, has experience in managing such hotels in India and abroad. Therefore, the lease was only for the purpose of establishing hotel.
Yes.
Only for the purpose. And Marriott, I don't know, it might have. Marriott is an international hotel. It has establishments in England and other places. Mount Marriott participated, Marriott was gone. It is also mentioned there that the project must be within the ambit of the applicable LUDC and the building regulations apart from other acts and rules. The petitioner submitted a bid which was accepted and the lease deed was executed for a period of 99 years, with which an option of renewal for another 9. Said lease deed specifically mentioned that the lessee shall, in the said period, pay all present and future extent charges and other imposition of every description in respect of the devised land and the building erected or to be erected within. Next paragraph. The lessee shall, at his own cost and expense, start construction of hotel complex buildings and structures within 3 months from the date of the final sanction of the building plan by Kolkata Municipal Corporation for the purpose of setting up five check well with the boundary wall such and such. Let's see. The lessee shall, during the subsequently, strictly adhere to and follow prevailing rules and regulations as stipulated, including under the provisions of the KMC Act. Section 45 of the Town and County Plan Act relates to prohibition of development without payment of development charges and without permission. It says, after coming into force of this Act to any area and subject to the provisions relating to development charges and other provisions, no development, institution, or charge or use of any land shall be undertaken or carried out in that area without obtaining a certificate from the concerned authority certifying the development charges paid in. No such development charge is levied. Section 102(1) of the said Town and Country Plan Act gives provision for levy of development charge, and Section 102(2) gives the person liable to pay such charge. Section 103 of the Act, is Bengal Town and Country Plan, gives the rate of development charge. It says the state government shall, by notification, fix of the rate of development charge for land to be used for carrying out any other development there. The rate of development charges are given by notification dated 15/9/2003 of the Government of West Bengal Urban Development Department, the rates of development charges in respect of planning area under Planning Authority and Development Authority under Development Department was notified. As per the said notification, the rate of development charge for residents is 40 per square meter, for industry such and so, and commerce rupees 3,300 per square meter. On the basis of calculation of development leviable in the definition of the state urban development charge. The legal basis for this is the important paragraph. The legal basis for claim of development is the binding contractual agreement. The provisions of Westmore Town and Country Act. I have not entered into any contract with the claims. Kindly remember it. I have not entered into an agreement with the claims. I have entered into lease agreement with KMDA.
Yes.
They have referred to section 45, 102, 103, and below this agreement. And at the end below section 45 and 103. Kindly have a look at the town and country. Is the book available to your lordship below? Town and country.
Town and country.
There. Original.
Yes, sir.
My lord, kindly turn to section 31 first. I won't read. I
Yes.
only take your lordship's ahead.
Section 31.
31. Land use and development control plan. This is the preparation. Look at the kindly chapter 6, head note. Preparation of land use and development control.
Yes.
Being done by the development authority, not KMC. A planning authority or development authority is KMG. Then kindly turn below to section 32. Deleted. Deleted. Section 32 is no longer there. 33. Land use and development control plan. We are not concerned. 34. Power of the state government to direct preparation of land use and development. Then section 36. Public notice of the preparation of the land use and development control. 37. Approval of the state government.
Yes.
Section 39. Reference to High Court questioning the validity of the land use and development control. Section 40. Amendment of land use and development plan. 41. Changes to land use and development. 42A. Validation of plan prepared or adopted prior to coming to force of the West Bengal law country planning. 43. Power to acquire land and land acquisition. Now, my lord, kindly turn to chapter 7. Control and development of the use of the land. After coming into operation of any land use and development control plan in any area, no person shall use or permit to use any land or carry out any development in that area, otherwise than in accordance with such land use or development, provided the planning authority or the development authority may allow the continuance for a period of not exceeding 7 years, use and upon such terms as may improve concern authority of any land for the purpose and to the extent for into which it is being used on the date. Now, my Lord, kindly turn to paragraph section 45. This is the section relied upon in the section 45. Kindly turn, my Lord, page 115. In the letter, they are referring to section 45. After coming into force of this act to any area and subject to provisions relating to development charge and other provisions of no development institution or change of use of any land shall be undertaken or carried out in the area without obtaining a certificate of concerned authority, certifying that the development charge as labor on this has been paid. I have paid more. 4 crores I have paid, kindly stand below. I have told your lordship, sanction and development charge. Paid corporation. That's the second. Finally, paragraph 6 of my notes.
Yes,
This is not bank guarantee. Total payment. Page 80 of the rate petition. I have paid 4 crores. I have paid it before undertaking the development. At the time of getting the plan sanctioned, I have paid the sanction fee and the development, though I didn't know it. Subsequently, it appears from the certificate of the KMC that I paid 4 crores. Now, kindly turn to section 45.
yes,
After coming into force of this act to any area and subject to provisions relating to development charge and other provisions of this act, no development institution or change of use of any land shall be undertaken or carried out in that without obtaining certificate from the concerned authority, certifying that has been paid. Now there is no dispute at the time of sanctioning the building plan. I have paid development. That is the certificate, page 80.
yes,
And they are disclosing the basis. Page 80, Milo. At page 81.
page 81 is the type copy.
Yes. I paid it. There is no dispute, Lord. Till today, there is no dispute. And this liability to pay is at the time of undertaking the development. This liability to pay is at the point of undertaking the development, not after completion of it. Kindly be satisfied. There is no dispute that we have paid this development fee along with the sanctioning fee. There is nothing, no disclosure in so-called, nothing in the so-called disclosure about any default. We have paid the bank guarantee in this, deposit the bank guarantee in respect of 3 crores subsequent charge at the time of completion. And the legal basis is at page 115. Contract. Non-null High Court directed to disclose, and they are disclosing it at page 115. Third paragraph. The legal basis, as the logically got it below.
Yes.
Page 115, Roman 3. The legal basis for claim of development charge is a binding contractual agreement. Your lordship will not find anything in the contractual agreement making me liable, contracted between KMJ and myself. And the lessee, KMJ, the lessor. That's a contract. They are collecting a contractual fee or disclosing. Then the provisions of the West Bengal Town and County Planning Act, section 45 and 103. I will now take your lordship to 103.
So development started in July 2008 and notification came in the month of November 2008. Sir, sir development started in the year month July 2008 and notification came in the month of November 2008.
Now, my lord, kindly turn. To section 102, they have referred to section 103. At page 118, they have referred to section 103. Legal basis 45, legal basis threefold. Contractual agreement, section 45 and section 103. 45, the liability to pay the development charges before undertaking the development. Kindly look at it. Section 45, before I undertake.
Yes.
This is not at the completion stage. This is before I undertake. Kindly read section 45. Before I undertake, I have to pay the development charges. And I have paid the sanction fee, development charges, have undertaken the development. It is complete. When I go for completion certificate, they are asking for more. Kindly turn to section 102.
102.
Yes.
Development charge.
Levy of development charge. In accordance with the provision of this Act and the rules made thereunder, and with the previous sanction state government, every planning authority or development authority shall by notification levy or charge, a charge, hereinafter called the development charge, on the carrying out of any development or change of use of land for which permission is required under section 7, chapter 7, provided the rate may be different for different parts of the purpose of this subsection. Development shall be levied on any person who undertakes or carries out the development or changes in such use, notwithstanding anything contained in subsection 1 no development charge shall be levied on the development or change of use of any land vested. Kindly read this subsection 3 of section 100. This property is vested in whom? KMDA.
Yes.
Lessor. KMDA is a local authority. I think that will not be disputed. KMDA is a local authority under General Clauses Act.
Yes.
This property is vested in KMDA. KMDA is the lessor. Can any development charge be levied on this property? ওখানে PN মুখার্জি সাহেব আর মুরারি দত্ত সাহেব এই অরিন্দম
বলুন।
ওখানে একটা PN মুখার্জি সাহেব আর একটা মুরারি দত্ত সাহেবের জাজমেন্ট আছে বার আছে তোর কাছে তো Now, my Lord, who kindly consider this question. In the property is vested in which authority? Me, I am the lessee, or in the KMDA, the lessor. ভাইখানে মোল্লা টিপি এক চলে গেছে হঠাৎ বলছেন মোল্লা চলে গেছে কার কাছে আছে
স্যার
My
মোল্লা
Lord, I'll
এনেছি
take you. এই মোল্লা টিপি একটা গেছে
এনেছি
দেখা তুলে দিতে হবে
হ্যাঁ বলুন আমি দিচ্ছি
টাকা পণ্য করতে হবে 700
কোন পাতা বলবে তো জানি না আমি তাই বের করে নিই হ্যাঁ
Mulla 11th edition TP Act
পেজ
Yes.
771 771
My Lord, kindly turn page 771. Mulla is considering, my Lord, the nature of a lease, the rights and obligations under the lease. At page 771,
Yes.
kindly turn, my Lord, to fourth paragraph. A lease, therefore, as your Lordship got it, my Lord, fourth
Yes.
paragraph.
Yes.
A lease, therefore, is not a mere contract, but is a transfer of an interest in land and create a right in them. Such an interest of a tenant is a right to property in the meaning of the Article 19(1)(f) of the Constitution. It is good against the whole world, irrespective of notice, and cannot be affected by any subsequent disposition of the lessor. The estate transferred to the lessee is called the leasehold. Kindly this sentence. The estate remaining in the lessor is called the reversion. Therefore, even after a perpetual lease, the reversion remains with the lessor.
Yes.
For that proposition, my Lord, I am citing your Lord, citing before Lordship two judgments. One by Justice Murari T.N. Mukherjee and the other by Justice Murari Mohan. That even in the case of a lessor, permanent lease, the property remains vested in the lessor. The property, the reversion remains. Kindly read the next sentence. Lord. That paragraph, kindly rest of it.
তাই করলে রাখলাম
Kindly, my Lord, turn to page 771, Mullah. A man, I am reading from page 771, bottom.
Got it.
771, bottom.
Yes.
Mullah
A man who being owner of the land.
is a judgment of Sir Lawrence Jenkins. A man who being the owner of the land grants a lease in perpetuity and carves a substantial interest out of his own and does not annihilate his own interest. This result is to be inferred from the use of the word lease, which implies an interest still remaining in the lessor. Before the lease, the owner had the right to enjoy the possession of the land, and the lease and by the lease he excludes himself in the currency of the right. The determination of the lease is removable, and there is nothing to do. Now, my lord, on this paragraph, on this point, there is two judgments. One by Justice P.N. Mukherjee, the other by Justice Murari Mohan. This is P.N. Mukherjee, sir.
হ্যাঁ দিয়ে দিয়েছি
It's 1968 to Calcutta. ILR 1968 to Calcutta. Not AIL. Kindly read that down. Very simple language.
Yes.
The two expressions, owner and permanent leave, are not synonymous. The word owner must be given its ordinary connotation or usual meaning. That is, a person having full and absolute ownership of disputed property and would not include a permanent lessee. I am a lessee for 90 plus 90 years. I am not the owner. In whom the ownership rests, the KMD. The
Yes.
property vests in a KMD. And section 103, subsection 3 says that if the property is vested in a local authority, no development charge. Kindly refresh your memory, Lord. 103. Very good. Section 103(2) excludes the property vested in the local authority.
Yes. Section 102, subsection 3.
Yes. Excludes the property vested in local authority.
Yes. Central government, state government, or any local authority.
Now, KMD is a local authority.
Local authority.
KMD has granted me a lease. He does not deprive himself of ownership. Kindly turn below to another judgment of Murari Mohan Datta. Justice Murari Mohan Datta is reported in 77 Calcutta.
Yes.
77 Calcutta 424. Kindly look at the head note. In the case of persons having unequal rights to a thing, the person whose rights are indeterminate and residuary is the owner of the thing, and not the other person who have such rights or have only lesser rights. Lessee is not the owner of the property, in the meaning of the act. So, a permanent lessee also is not the owner.
Yes.
Mullah, that is P.N. Mukherjee and Mr. Justice Amender, all are holding. There is no dispute about it. What is reversion? If the lessee dies without any successor, the property will go back to the lessor,
Reverted back to the lessor.
revert back to the lessor.
Revert back to the lessor.
When the lease expires, it reverts back to the lessor.
That is the reversal.
And the property is therefore vested in the lessor. Property is vested in the lessor. Finally, look at section 105 of the transfer property. The owner is conveying to the lessee a right to enjoy the property. Section 105. Kindly look at section 105 definition of lease. A lease of immovable property, 105.
Yes.
A lease of immovable property is a transfer of a right to enjoy such property, not the property itself.
Yes.
Right to enjoy such property, not the property itself. Section 54 provides for transfer of the property, sale.
Sale.
Lease is a transfer of the right to enjoy such property, made for a certain time, expressed or implied, or in perpetuity, and in consideration of a price paid upon us, or a share, service, or any other thing value. Therefore, in the case of a lease, the property is vested in the lessor. Owner, not really value, lessor, owner.
Yes.
Carves out the right to enjoy and transfers the right to enjoy to the lessee. There is no dispute.
Yes.
There is no dispute in our case that I am a mere lessee. I have to make the construction and the reversion is right remains to the lessor. How can you impose the development charge on me? First, I have paid the development charge at the time of sanction of the building. Then at the time of completion certificate, go there, another 3 crores. Second imposition in any case is not provided for. It is before undertaking the development. You impose the development charge. That was imposed at the time of undertaking, at the time of sanction of the building. And when I go for the completion certificate, I'm called upon to pay another 3 crores. This is not section 45. Kindly read section 45 once more. Section 45 provides for imposition before undertaking.
Yes.
I have paid. I have completed. The hotel is functioning. At the time of completion certificate, they want another 3 crores. My lord, in this connection, kindly recall, you have got a copy of Constitution of India, Article 265. Kindly turn below to Article 265. Hey, Annam,
স্যার দিচ্ছি আনাচ্ছি
thank Judge Sahib Kaji আছে।
হ্যাঁ স্যার পেয়ে গেছেন স্যার
Is it a constitution, my lord?
হ্যাঁ 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 পেয়ে গেছেন
Article 265.
Yes. Article 265.
The Constitution
Not
declares
to be imposed save by authority of law. No taxes shall be levied or collected except by authority of law.
therefore, without the authority of law, you can't impose or collect. The act authorizing you to levy and collect authorizes you to collect from persons other than the local authority.
Yes,
The property is vested in the local authority. Expression is the property is vested in the local authority. I have satisfied your lordship that in this case the lease is granted to the KMD. I am merely the lessee. If the lease is granted in the local authority, you can't impose it. What is exempted? Kindly look at section 103. The property is exempted. Kindly turn to 103. It is a land which is exempted. Surajit, now bhai. Jai Surajit.
স্যার আমরা পরের দিনে করব
My lord, I can't continue for long and I will hand over.
I understand. I understand. Very well. Just I have understand the entire submission.
Kindly turn below to Article 265 and then 103.
Yes,
It is an input, it's an exemption of the land. Look at the language. What is exempted? 132.
notwithstanding anything contained in subsection 1 and 2, no development charge shall be levied on development or charge of use of any land vested.
The land is exempted.
Yes,
If it is vested in the local authority,
vested in or under the control or possession of central government, the state government, or the local authority.
therefore the land is exempted.
Yes,
Rightly or wrongly, you have imposed foreclose at the time of granting of the sanction. And now at the time of completion of this project, you are again asked for 3 crores. I have deposited, I say you are not entitled. Kindly remember, tax cannot be levied or collected.
yes,
Without the authority.
Now in this connection, Milord, I am a human being. I have got I had the privilege of doing a case in Calcutta High Court where for sanctioning of a building plan, they were collecting development charges. Development, why? I would have to develop the drainage system. A large number of cases were moved in the High Court, and ultimately the matter was heard by a division bench
yes,
of Justice Bhaskar Bhattacharya as a presiding judge. His lordship held that development charge cannot be imposed because the act does not authorize you to do it. The tax cannot be collected, levied and collected unless the act authorizes. In your rules or something else, thereafter the plan was modified. Lord, let us continue on some other day.
okay. Thank you.
Grateful, Lordship.
Please take down.
Yes, concluded.
No. Sri Shopinath Mukherjee, learned senior advocate, argued on behalf of the petitioner at length. Argument continues. Let the matter appear in the list. July 18th. July 18th.
Grateful, Lordship.
July 18 at 10:30. 10:30.
The interim order is to be extended.
Okay.
Here is a part matter, my lord.
Otherwise, the problem.
What you now? Matter heard in part.
Oh, the interim order has to be extended.
Yes. Interim order passed by this court on the earlier occasion is further extended till August 22nd,
They will,
2025.
and they will
Or until
do the
further
bank,
সেটা তো হচ্ছে
bank guarantee to be,
হচ্ছে সেটা তো
ওটা না দিলে তো হবে না।
বলেছি যে
whether this is at all. Well, one order I missed, my lord.
তোরা ব্যাংক গাড়িতে কি করছিস রে?
না স্যার, সব সব দেওয়া আছে, কোনো অসুবিধা নেই।
On order,
ও
on
একটুখানি
one
এই
order, I
সত্যজিৎ আমাদের সঙ্গে গল্প করছেন, মামলা হয়ে গেছে।
did not place, my lord, while I took that point. I should place.
You take note and you place your point.
Yes.
বইটা দিন।
একটু লর্ডশিপ বন্ধ করুন।
Down at country.
যেটা তারটা গেছে না, তার কি দারুণ হচ্ছে, চুপ 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 চুপ। He said, my lord, the screen is blinking. So I told him, he's saying the wire has to be replaced. This side screen.
Okay,
My lord's screen is not blinking.
No.
Our side.
blinking.
একবার বন্ধ হচ্ছে।
On the next matter. দেখো,
Supratim Dhar, learned senior advocate, my lord. My lord, until he comes, may I place the
But item number 2, I was appealing for the KMC, my lord. Lordship will kindly go through your lordship's last order where we had filed an report in the form of affidavit. My lord, they were supposed to, my lord, file their reply to that report. I do not know whether they have used any report or not. My lord, I have not been served with any copy. Lordship kindly goes to your lordship's last order, 16th May.
my lord, due to some personal difficulties, my lord, I could not prepare the reply towards the exception towards the report filed by the KMC, my lord. My lord, kindly extend the time.
Obliged, my lord. That can be done.
Kindly extend the time. The report.
দিদি,
KMC. কোথায়?
so reply is not ready.
My lord, I'm ready.
My lord, I'll have to, my lord, bring few documents, my lord. In absence of them, I do not wish to, but kindly have a look.
My lord, only one submission. First, let them clarify as to
KMC is
whether they
there.
will. Not only one thing, my lord. First, let them clarify as to whether they will file any exception or not. If they say, no, we do not want to file any exception, then my lord will decide the matter on any other date, my lord. Or if they say that they are going to file exception, let them do it. My lord, the pleadings have to be completed.
No, they have given leave to
Yet,
file the reply.
not yet, my lord. Kindly have a look.
My lord, what is he showing to your lordship, my lord?
If you do not stay in the room, how could I? This is the document of KMC. KMC has rejected my mutation application by saying that this has been used for park
My lord, may I
purpose.
say one thing? If my lord, that has been done, then the writ petition, this particular writ petition has lost its force. My lord, this is a new cause of action. He will have to, my lord, I do not say what he will have to do, but if the KMC has taken a decision, this decision is being taken in compliance with the order passed by the Honorable Coordinate Bench in the earlier writ petition.
Let
So, my lord, they are compliant with
let
that.
me place my case, my lord.
My lord,
Let
right
me
now,
place
my lord,
my
I am in
case.
some difficulty. Right
Now,
now,
my
I am in
lord,
some
Sir,
difficulty.
you said reply or not?
My lord, I need to bring this on record.
File the reply.
Yes.
File the reply.
Grateful,
Yes.
your lordship, my name may be recorded.
Okay. Learned counsel appearing on behalf of the petitioner seeks leave to extension of time for seeks accommodation for extension of time to file reply with a ground that some specific
New
document-
development has taken place.
specific document has to be placed before this court regarding new development taken place regarding the action of the authority. Let the considering the submission, let the file for
Correct.
filing
আগের proceedings
Reply.
KMC কি বললো?
against the supplementary affidavit
এটা কবেকার proceedings? সেখানে বললো কি আমি
be
কিছু
extended
আর
for further period of 2 weeks. List the
My lord,
matter.
lordship, kindly record that KMC is appearing. My name may be recorded for KMC.
Okay, your name would be there, original.
Grateful to your lordship. Madam, led by Mr. Alok Ghosh. Madam, led by Mr. Alok Ghosh.
Let the matter appear in the list on July 18,
ও করেছে
July 18. Grateful to your lordship.
সুপ্রিম কোর্টের পরেও
2025.
বলছে
Much obliged.
under the heading to be mentioned.
But I'm taking your lordship's kind leave, my lord. I'm taking your lordship's kind leave, my lord.
Yes.
May I leave, my lord, may I leave? Obliged, my lord. Grateful to your lordship.
So my lord has kept it on.
July 18. 18. July 18.
I'm deeply appreciated.
Huh? You know? Who is for the petitioner? So the motion আসবে তো নাকি? তাহলে কখন আসবে? এটা তো এখন আসবে না? আচ্ছা। আর কে আছে অপোজিট পার্টি? রেসপন্ডেন্টস? Call next matter.
I'm for appearing for the petitioner, my lord.
My lord, I beg to differ on behalf of the state. My lord, this is ready matter. My lord,
Yes,
any day, my lord, it will, my lord, that it will not take much more time.
I have
because
no
it can-
objection for fixing the matter for hearing, my lord. Not all I'm praying, my lord, that the interim order may be extended, my lord.
Whether the pleadings complete?
My lord,
The matter is ready for
matter is ready for hearing any day, my lord,
Yes, ma'am.
excepting 26th and 27th.
May I draw your attention, my lord, attention to the
I-
last order dated, my lord.
Extension of the limited interim order.
Yes, ma'am.
Yes.
I'm grateful to my
Learned
learned
counsel appearing on behalf of the state submits that the matter is ready for hearing. Pleadings complete. So a date may be fixed for hearing of this matter. Considering the submission, let the matter appear in the list under the heading of hearing
my lord.
on July 24, 2025. Full stop. Interim order passed by this court on the earlier occasion is further extended till July 31st,
My lord,
I'm obliged, my
2025, or until further or whichever is earlier.
my lord,
I'm grateful, my lord.
deeply obliged.
I'm appealing to the petitioner, my
On
lord.
this matter, my lord, I am
With the
the
amendment.
state, my lord, this is also, my lord, ready matter. My lord, on the, my lord, interim order is going on extending time after another. Let it
What
be
is the issue involved? Whether the long matter?
Here the, my lord, relating to the unauthorized construction by the municipality itself. The order of the
By the municipality itself.
My lord, I'm for the
You are
petitioner,
the
my lord.
petitioner.
municipality,
You are the whole municipality.
I'm for whole the municipality.
My lord, the subject matter of challenge is the order of the subdivisional officer. My lord, let it be fixed any day. Any day. My lord, if it is, my lord, 2nd or 3rd July, my lord, because, my lord, this thing should be, my lord, hard out.
Madam, we are
The earlier.
resolution about one toilet for restroom for the vendors. That now PWD is claiming the land is belongs to PWD. Madam, that land is classification is knowingly development department is the owner of the land in
It is
question.
knowingly, it cannot be to the
we are-
any other
we are
person save and
concerned for
except the
for
government.
the interest of the public, my lord. They are claiming we are the.
My lord, just for public, you cannot encroach any land.
We are renovate. My lord, we are renovate only.
He cannot, my lord,
That
construct
that
illegally
constructed
without, my lord, following the law.
July
partition, my lord.
I will not be here.
My lord.
Any day, my lord.
Your
I
lordship.
will be here only on 14. Prior to that, I will be circuit.
14th, my lord, any day, then, my lord, in 24th, my lord, the second matter.
24th.
24th in the second matter. Let it be extended with, till 31st.
Please take down. This matter appears under the heading of extension of interim order. Learned counsel appearing on behalf of the state authority submits that the matter is otherwise ready for hearing, so any date may be fixed for hearing. Concerning the submission, the matter be fixed for hearing on July 24th, 2025. Full stop. Interim order passed by this court on the earlier occasion is further extended till July 31st, 2025 or until further whichever is earlier. আচ্ছা শোনো, প্রথম ম্যাটারটা একটা অর্ডার দিয়েছিলাম, প্রথম এক নম্বরটা ওকে দিয়েছি, অনেকটা অর্ডার তারপরে এটা
But it is fixed on 24th.
24th is the date of hearing,
And interim of
extended till 31st.
Sir.
Yes, sir. For the petitioner, this matter, the interim order was passed on 5th of December 2023, so extended, my lord, lastly till June 2020. Kindly. But I am also, my lord,
Benefited because of
Yes.
sand mining lease.
that is another, my lord, the lease has,
Because of
the expiry of the lease.
Neither he is enjoying nor the government is asking.
Expiry of the lease, my lord, that is another aspect, but lordship kindly, yes.
Extend the interim order, fix that. Lordship, kindly, sir. Prayer of
Yes, sir.
hearing parties.
It's a joint prayer. My lord, the man,
Petitioner is a sand mining leaseholder. His lease
Very
has
well.
been expired due to some COVID pandemic and for other reason
No,
he
no,
has
no.
paid for extension. That was rejected. Against that order.
no, my lord, no. The matter is, my lord, altogether different, my lord. The thing is, the petitioner was a successful bidder, my lord, was given a possession in respect of a mining plant. Thereafter, my lord, on some religious issue, my lord, the local residents, my lord, raised some objection. The possession practically, though, was, my lord, by, my lord, document it was handed over, but factually didn't enjoy the possession. This honorable court, all time and again, my lord, decided that the, my lord, possession is the date of inception of the lease. But the possession, according in my case, my lord, this is not a possession. This possession cannot be constituted possession. And that is to be decided.
My lord, whatever may be the what is the lease period?
I appear on
5
behalf of
years.
the state, my lord.
5 years,
He-
my lord, expire by
He was given lease, but he did not
my lord.
extracted sand from by his own volition. By some reason or other, he did not extract
But
the
this
sand.
is not
and
my
that-
luxury. After paying the entire
and
mine,
then after
and-
5 years, he has
But-
come before the
but-
court after the expiry of the.
let him come, let him
my lord.
submit, then I can.
Fix a date for hearing, my lord.
My lord, the entire lease rent has been paid in advance.
Yes,
See,
I
it
want it.
can't be,
Gajon Mela.
it can't be the luxury of the retribution and not to, my lord, extract.
5-6 days. This cannot be
My
the
lord, on
reason for
five-
not
my lord,
extracting
on
sand.
5 occasions, my lord, the hearing was held. No order has been passed. I, my lord, only expected some, my lord, cooperation from district authorities so that I can extract sand. No cooperation was rendered. It was not my luxury
I
not
can
to
show to your lordship, each and
Lordship, kindly
every
extend the
strict
interim order, my
cooperation
lord.
has been given.
Kindly extend the interim order and fix up the matter.
Pleadings complete.
Reading is, well, the report was short for, the report has been filed, the exception to the report, I have all.
You have filed the exception. Having heard the learned counsel for the parties, it appears that the matter is ready for hearing. Let the matter appear in the list on July 25, 2025. Under the heading hearing. Full stop. Interim order passed by this court. We extended till July 31st. July 31st.
They will pay for some precedence.
Because of that fact, I am only sitting on
PMA
14.
program.
Before that, I would not be there. I will sacrifice.
It's not available.
So bench is not available. That is the
First one, kindly take up this matter on the 25th, 25th.
25th. Before that, it is not possible. Already fixed several matters like that.
Also on 25th, kindly give some.
18 কি আছে দেখো তো, 18 তে লিস্টে দেখো।
12:30 করো।
18 তো ফাঁকা আছে। 18th, 18th,
We don't.
Convenient to the Honorable Court.
okay, 18th করো। Extended 31st. 18 is the date of hearing.
Yes, my lord. Get it.
Yes.
Yes.
I beg to appear on behalf of the petitioner, my lord. Well, the interim order is going to expire today, my lord. Pleadings completed, my lord.
18, both the matters.
Issue is entirely different.
Having heard the learned counsel for the parties, let the matter appear in the list on July 18, 2025, under the heading hearing. Next para, interim order passed by this court, further extended till July 31st, 2025, or until further order, whichever is earlier.
I appear for the state respondent.
What application?
Application for
Take the mic.
This is the application for restoration along with section 5 application. This is a change brief, my lord. Matter was
February 5,
yes, my lord.
2024.
Thereafter, no communication. I visited. I have elaborated the paragraph 10(9). Kindly find. When I visited the earlier lawyer's chamber, then I came to know that the matter has been dismissed for default. Thereafter, new advocate was engaged on 28th February 2025. Now this application has been filed.
What is the status? Whether a report or affidavit placed by the authority?
Report is lying with me, my lord.
I have
I am ready with the report. My lord, with respect to the restoration application, my lord, I normally don't come in the way, but my lord, in this particular application, my lord, it is practically a test of the highest limits of the judicial tolerance. Why I say this? Well, 7 except paragraph 7, nothing is stated. And I came to know only on that date that it has been dismissed on. In 2025, I came to know for the first time. That is the paragraph 7 is the only pleading, my lord. And nothing. And so far as the section 5 application, it is just cut, copy, paste, nothing otherwise.
9, 10, my lord.
More the reason is section 5 is practically not required in writ proceedings because section limitation act doesn't apply. It is the discretion of the your lordship, my lord. But there absolutely there is no explanation, nothing. Paragraph 7 only.
No, my lord. Paragraph 9 and 10. May I read, my lord? That you petitioner states that your petitioner visited the chamber of the arts and learned advocate of Mr. Shekhar Bormon on 6/1/25, when the said advocate returned the brief along with his no objection remark, and thereafter your petitioner handed over the brief to the present advocate on 22/2/25 after due consultation with him. Because date-wise I've explained why the delay has been caused.
Matter has been dismissed on 5th February 2024.
Because the change brief, my lord, kindly appreciate that there no reason to the petitioner how to came to know the status of the case, my lord.
What is your what is the claim in the writ petition?
Case is that the grandfather of the petitioner
was an allotee from the Kollani Development Authority. A plot was handed over, a allotment was made in favor of the grandfather of the petitioner, and the grandfather paid all premiums. Everything was paid, but lease agreement was not
Renewed.
renewed. And thereafter, in the meantime,
You have the
My lord, I have the report with me. 1963, originally given the possession. Since then, no construction. Dues were mentioned in the show cause notice. None of the times it has been responded to even. And thereafter,
but by various orders of this land government, let I show and kindly let the list out, my lord.
have you served the report?
I am serving it right now, my lord. Arekta copy dekho na, my lord.
Please take down.
My lord, I'll hand it over a copy, my lord, in course of the day. And my lord, kindly
And the
have
affidavit service
can I have a
you-
copy of the writ petition also, because as well there was some
may not
other-
take- Affidavit
Can
service
2 of
became
2025. What is this?
affidavit service, my lord.
Okay. Can 2 of 2025 is an application for restoration of the instant writ petition, which was dismissed for default by the order of this court dated February 5, 2024. Next para. Can 3 of 2025 is an application under section 5 of Limitation Act for condonation of delay of 421 days occurred in filing the application in Can 2 of 2025. Heard the learned counsel for the petitioner. Strong objection raised by the learned counsel appearing on behalf of the state. Having heard the learned counsels for the parties, it appears that there are substantial matter to be heard in this matter. Accordingly, it further appears that the grounds of delay narrated in the application being Can 3 of 2025 appears to be sufficient. Accordingly, the application being Can 3 of 2025 and Can 2 of 2025 are considered and allowed, and both of them are disposed of. The order passed by this court on February 5, 2024. Be hereby set aside and recalled. Full stop. The writ petition being WPA number 7112 of 2020 is hereby restored to its original file and number. Full stop. Next para. Mr. Ganguly, learned counsel appearing on behalf of the respondent authority, place the report. Let the report, including the statement of facts and documents, let the report be taken on record. Full stop. A copy of report has already been forwarded upon the petitioner. Full stop. The matter is otherwise ready for hearing. Let the matter be appear in the list under the heading of hearing on July 18, 2025. Full stop. The petitioner is at leave to use reply stroke exception, if any, against the report within the adjourned date. Can 2 contrary disposed of.
I'm great.
Can 2
अच्छा, ये नंबर नहीं है तो कॉपी नहीं ली
Affidavit service be filed.
affidavit of service taken on record.
Great.
Nine, that's the item 9, item adjournment.
30 to 12.
Item 9 to degree adjournment matter.
My lord, 12:30 part
The adjournment will be 9.
My lord, that
9.
Nine. Item 9. Both side আছে adjournment. Sir, item 9. Sir, item 9. 9 দেখে নিন adjournment করে।
না আমার বলা হয়নি Well, just to recapitulate, I have concluded this is the land without any acquisition taken away from me for purpose of flyover and lecture.
So challenge the jurisdiction clearly held that without any proceeding you have acquired. Then directly with the consequential. Consequently, relief is allowed. They are asking me for a bigger amount on the garb of this agreement. We are not agreeable. We are praying for rent compensation from 76 till date, till notification is published, and if the notification is published, consequential relief. I have cited my judgment for এটা কি সম্মান চ্যাটার্জি and it was I mentioned this matter, but it could not be handed over the judgment. This is reported in 2018 3 CHN 1 CHN 365. এটা দিয়ে সম্মান চ্যাটার্জি তুই তো ভালো হারে জানিস বাজারের মামলাটা লিখতে দে না ও আমি দিলাম জাজমেন্ট আমি দিলাম
জাজমেন্ট না স্লিপটা ও রেসপন্ডেন্ট লিখিনি না 2 and 3
স্লিপটা ঠিক আগে পৌঁছে
হ্যাঁ তিনে এটা 3 আমি 3 লিখে দিয়েছি না এটা না হ্যাঁ
প্লিজ একটা মামলা তো
করি
জাজমেন্ট
Rent compensation from the date of possession till the date of acquisition.
The date of notification has not yet published.
Notification not yet published.
Continuing. They are asking me to have the compensation and bigger amount shown to lordship on the basis of the purchase policy. And I have shown to lordship a division bench judgment where it said in this type of cases purchase policy has no manner of application. The division bench judgment decided by basis Odijit Banerjee.
Penal rate of interest is Supreme
Two
Court.
part. One is penal rate. It should be penal. And
Yes.
first remarks has been made in the judgment of Apex Court that you violated the law, a person has been deprived of his right to property.
So division bench judgment annex যেখানে বলেছে penal rate টা 10 times হবে
2011 1 SCC 648.
No, 2022 SCC online.
Yes, that is
4149.
Yes. 4149.
Yes.
And also we have relied on 2018 1 Calcutta High Court notes 365.
আরেকটা judgment petition এ রেফার করেছে
এটা সম্বন্ধ
এটা
সম্বন্ধ দিয়েছিস তো
হ্যাঁ দিলাম তো 365 হ্যাঁ Odijit Banerjee division.
Yes.
And my lord, there is a judgment I have relied upon, my lord. Justice Odijit Banerjee's division bench judgment for the proposition that the so-called direct purchase policy is not applicable so far as this type of matters are concerned. Because this has bond and land was taken in 1976. So 13 Act was not there. 13 Act and the purchase policy said the rules has not been framed, so you can purchase to expedite. It has been taken away, executed. So there is no question of expedition today. So 13 Act will not apply, and so far as the direct purchase policy is concerned, that's the division bench judgment. These two judgments I have referred, and my lord, one judgment I have referred for rent compensation that is reported in 2011 11 Supreme Court cases 648.
Rent compensation.
Rent compensation. How? When you are utilizing the property without any proceeding, it should be penal, not rent.
And
Paragraph 13 to 15, my lord, kindly see. My lord has probably marked that.
Yes.
High Court এর এই judgment for it is to এই High Court এর এই judgment 10 times also. It's for it.
And another judgment I don't know why they were annexed.
No, annex because এটা আমাদের
Page 221, your lordship, kindly see of your lordship brief. And can you take there as a cited judgment for your lordship consideration? 221. Yeah, just recapitulation. Nothing else. I have concluded. I have said that. Act on judgment.
না না সম্মন চ্যাটার্জিটা আগের দিন বলেছে। না না সম্মন চ্যাটার্জি আগের দিন বলা হয়েছে।
2 to 1, my lord, has said that. Here, my lord, the court said you have to give 10 times.
223.
But kindly come to 223, internal page 3, last part 1 paragraph. As such, I feel that for such unauthorized occupation of the petitioner's land, the state respondent is liable to pay damages which will be not less than 10 times of the letting value of the said land of the petitioner.
একটা গভর্নমেন্ট অর্ডার কিভাবে হবে?
And you have another submission regarding portion of land which was not
Yes, yes,
utilized,
my
but
lord. Oh, sorry, my lord. My lord,
Yesterday,
I forget that, my lord.
on the previous occasion,
I say that a strip of land which is unusable today because the flyover is there.
Yes.
So under the statute, I've shown the statute to your lord.
28(4).
28(4), you have to accord also that. That's all. Everything is Lord's mind. I am not wrong. Well, may I come back?
Yes.
My lord, on the other day, my lord, I started
Not maintainable.
maintainable, I mean. My lord, there are, apart from that issue, here only issue that you cannot apply the direct purchase policy, you will have to acquire.
Yes.
Because facts remain, my lord, acquisition could not be done. There was a writ petition. Before that, my lord, some facts are necessary, my lord. If your lordship sees, this piece of land was utilized in early 80s. 76, 77, the land was utilized. Assuming, my lord, why assuming? It is an admitted fact that the land, the portion of the claimed land has been utilized for construction of road. Though that was, the petitioner cannot say that they were not aware of the fact of utilization of the land, because the land possession was taken and it was the road was made. Despite this, the petitioner first time came before this honorable court, my lord, with the writ petition in 2019. There has been a long wait. However, my lord, I cannot take that point because the writ was entertained and order was passed. Lordship will find, I am apprising this fact, my lord, there are reasons, my lord. If your lordship, if your lordship see turns to page 64, lordship will find in 2004, it is not that we did not take any step. The KMDA forcefully utilized that. When that land was needed for construction of the road, my lord, we sent a proposal in 2004. That, of course, when we detected that some portion of the petitioner's land has been utilized for construction of road, then a proposal was made. Ultimately, that proposal somehow, my lord, it is interdepartmental state and the requiring authority. Ultimately, acquisition was not done. In 2004, what was our proposal in page 64? Lordship will find 0.365 acres of land was proposed to be acquired. However, that proposal could not be given effect to. The petitioner in 2019 came for the first time after a long years. Since the land was utilized without acquisition, court took it in another, so that a citizen cannot be deprived of his valuable right. We are not against that. If you lordship, now lordship, I cannot go, my lord, now I cannot in this writ petition cannot question that order. If your lordship kindly turns to the order passed at page 209, I referred to page 64. If your lordship, for my satisfaction, if your lordship turns to page 64.
What is this?
Well, this is the proposal.
Mr. Talukdar, proposal or everything has gone after passing the order by Justice Tandon.
No.
We understand that you have taken steps, but ultimately the person has not received anything.
Not for that matter.
Yes.
Because we proceeded, this correspondence I am showing, because the quantum of land is in question. Now, to calculate the valuation of the land, the quantum of land is necessary.
Yes.
Here, our proposal was originally, if your lordship kindly turns to page 63 for a moment, first paragraph, last line, lordship will find that we wanted to acquire last line in specific portion which has already been utilized. My lord, I am emphasizing on this. What the petitioner is claiming now, I will show that. In specific portion which has already been utilized. So that was based on that, my lord. And another is 85, 86. Lordship, kindly come to. This is important for me. Lordship will find the subject, application for acquisition of total 0.365. That was intended to be acquired.
Page 68.
86. 86. In subject, I am not troubling with the body of that letter. And what the order was passed, Lordship, kindly come to the last order, year 209.
And 37 is the same. We placed on 37.
Yes, 37 can be looked into. No, ঠিক আছে তোমরা. My lord may see that not 37, 39. 39 also, lordship will find.
Yes.
My lord, this is 16 July 2018 order, implementation of which is sought for in this writ petition. Here, also the land, quantum of land is mentioned below 0.365. My lord, I showed to your lordship one letter of our that in specific portion which was utilized. So based on that proposal, which was shown to your lordship just now, that application of total land utilized, total proposed land is 0.365. Based on this, it was recorded 0.365 acres of land. My lord, I need not trouble your lordship reading the whole portion. Lordship, if your lordship kindly come to page 41.
Yes.
The operative part. This court finds that the possession of the land of the petitioner cannot be given to him, as the situation which is prevalent at present renders it irreversible. Since the KMDA as the requiring body have been informed to make a fresh proposal, this court permits the KMDA to make a fresh proposal within 4 weeks. This fact was recorded because in 2004 one proposal was sent to the LA collector that was not, my lord, acted upon. Then the collector raised some queries and requested us to furnish a fresh proposal. All these correspondences were there while deciding this case. That is why the court had given us a liberty to make a fresh proposal. Here, this line is very important, my lord, proposal within 4 weeks from date, strictly in terms of the extant rules, guidelines, or act applicable in this. My lord, I would like to emphasize this. This order was passed in 2018 when 2013 Act came into force. Since the rules was not made, my lord, I take the date of the passing of the order. This fact was apprised before the Honorable. The 2013 Act, the land cannot be acquired because there is no rule. In absence of rule, the state framed a policy which is called the purchase policy, by which can be applied. The court was made aware of this situation. That is why, my lord, here it is recorded in terms of the extant rules, guidelines, or act. It is not said.
2000 Act was already there.
There, act was there.
Yes.
But since no rules was framed, the act.
Okay. So in the year 2018, it was not framed rule.
Not framed.
Now
And
it
I think till date rules are not framed. That is why, taking cognizance of this submission, my lord, I personally, I appeared in that matter also. I can recollect, my learned friend also can recollect very well. We are not denying the utilization. Now, how it is to be compensated, that's the question. Taking cognizance of that situation, the Honorable Court, my lord, to my understanding, my lord, the recorded extant rules, guidelines, or act applicable. Had it been so, my lord, had it been the intention of the Honorable Judge that no, you will have to acquire it under 2013 because Act 1 and Act 2 is not there, 2013 is prevailing, was then. So you will have to acquire under 2013 Act. Here the very intent of the order was allowing the government to acquire as per the extant rules or guidelines or act. If in the meantime rules are framed, then act can be made applicable. This is one aspect of the matter. Now, this order was not challenged by the petitioner, questioning this. So why extant rules and guidelines? 2013 Act is to be applied. No other. So here option was given by the Honorable Court itself. The state was permitted because state was unable to apply the 2013 Act. Then, my lord, my learned friend wants the rest portion ID. My lord, the state is directed to take recourse for acquisition of the property as per the extant guidelines. Again reiterated. It goes without saying that the entire exercise shall be completed within so and so. So, in compliance of this order, the state calculated as per the prevailing policy, which is called the land policy of the state government. So that is strictly done in terms of the order passed by this Honorable Court in 2018 in earlier writ petition. The court has given this. Now, no precedent can be applied, no authorities can be applied, no. We are also aware of the proposition laid down in the judgments. But this was also, my lord, the court was apprised of this difficulty. That is why the guidelines word has been used. So what was the guideline? Guideline was the policy of the government, which was applied. Compensation was calculated, and they were asked to receive the money. They refused. In the affidavit filed by the state, all these documents have been disclosed. My learned friend will place it. So there is no scope. later portion, even the rent compensation, then another part. Lordship, may I read the rest of the portion? Then, my lord, I am reading the next paragraph, penultimate paragraph. Though this court finds that this direction has been passed to mitigate the situation, and to secure the ends of justice, yet this court cannot brush aside the petitioner has been deprived of his property without payment of a single farthing. Now this portion. The land acquisition collector, South 24 Parganas, is directed to determine the rent compensation from the date of possession till the date of an acquisition of right, title, and interest by the state, and shall pay the same to the petitioner along with 6% interest. There, the Honorable Court has also the interest also fixed. The rent compensation to be decided along with the interest at the rate of 6%. What has been done by the state? So there is absolutely no scope to reopen this issue. That other than 2013 Act will not, unless it is assessed under 2013 Act, will not receive. It is not open to the petitioner to say this. And, my lord, in compliance of this, my lord, we have made a proposal. Now I am coming to this. On 7th September, Lordship may kindly take note of this. On 7th September 2018, we made a fresh proposal in compliance of the Honorable Court's order for acquisition of 0.31 acres of land. Not
when you made the proposal?
7th September 2018. For acquisition of 0.31 acre. Plus, you will find this from the documents annexed with the affidavit of the state. Why, my lord, it was 0.365 was under proposal. But before making fresh proposal, we conducted a joint survey. There we found that no, not even 365 was utilized. Actually utilized land is 0.31 acres. Actually utilized. So when we were permitted under the orders of the court to make a fresh proposal, we conducted a survey, fresh survey, and found that 0.31 acres was actually utilized for construction of the road. And based on this proposal, the state authorities assess the compensation according as per their, my lord, guidelines, that is the policy. And KMDA, after assessment, the estimated amount was, my lord, the assessed amount was 7 crore 51 lakh 1,735 in total. Plus, you will get all these figures in the affidavit, the documents. And that was as per the policy, as per the land policy of the government, 50% together with the land value, 50% solatium is permitted. Whereas in 2013 Act, 100%. That is why they want the 2013 Act to be applied. Here, after assessment, being the requiring body, we are obliged to pay the amount. Requisition was made to us, and we furnished the amount on 20th February 2020. We have furnished the amount to the collector. We have deposited that amount on 20th February 2020.
Document, page, your affidavit in opposition.
My lord, I have not filed any affidavit. The state was directed to file affidavit, and state has disclosed all these documents. It is not denied that we have not furnished the amount. My lord, date, kindly take note of the date 2020. 20th February 2020, we have furnished the amount with the collector, the concerned collector.
20th February 2020.
So this is the proposal we made in compliance of the order. And in terms of the requisition made by the collector, we have deposited the amount as assessed by the collector for disbursement to the petitioner, which the state sought to disburse, but the petitioner did not accept. My lord, now this is, my lord, I need not make any lengthy submission on that. My lord, now the question is another issue that they have raised, whether we were, my lord, I am here bound. Order records our proposal 0.365. We have made a proposal in terms of that order in respect of 0.31 acres. Here, 0.365 was the quoted in the order that referring to our proposal, not the actual use. My lord, here we have, when we have found that we have not used 0.365, but we have used 0.31 acre, we have made this proposal and the valuation is certainly based on 3.1. This petitioner, if your lordship turns to page 234, now how the fabulous amount they are claiming. 234, lordship, kindly turn. My lord, got it? It's a valuation obtained from IGA, registration office. Lordship, land details, lordship, kindly come to the middle, at the middle, the table. Here, lordship will find L1 schedule, land proposed, commercial use. Lordship, kindly, my lord knows that how the valuation is determined based on the data furnished, the data submitted for commercial use. Then lordship will find the quantum of land 0.41. So what the amount they are now claiming? In one hand, they have obtained this alleged valuation showing the land as for commercial use, and the quantum is also 0.41. 0.41 neither proposed nor utilized. They are not disputing that we have utilized more than 0.31. It is not their case. Now the another question which has also fallen from your lordship, based on the argument made by Mr. Basu, that on the land after acquisition, if any portion remains unutilized and unusable rather, then what the acquiring authority should do. Here in this case, petitioner has not made any case, made out any prayer or case for that this portion, he is concerned with utilization of the land. The court directed us that you have utilized the land without acquisition, so pay compensation. We have found out to what extent we have utilized. To the extent we have utilized, strictly in terms of the Honorable Court's order, we have made a proposal, assessment was made. So the portion they are unable to use or utilize, whether in this proceeding that can be tagged. My lord, in my respectful submission, that cannot. For that, they are to move the government, the acquiring authority. You see, because of your acquisition, because of your these steps, this portion of my land becomes unusable. So either acquire it or pay me compensation. This case was not made out in either of the writ petition. So that relief the petitioner is not entitled. My lord knows it is a settled principles of law that specific pleading and prayer should be there, right from Bharat Singh's case. My lord, still that the proposition laid down in Bharat Singh's case is still being followed, and that is the law. That case they have not made out. Their allegation was utilization. To the extent we have utilized, we are ready to pay. We means the state and the requiring authority. So the amount they are claiming, my lord, I have shown to your lordship page 234. That is erroneous. That valuation cannot come. And here, to the extent we have utilized 0.31 assessment made, and they are bound to accept it because they cannot, without that order gone unchallenged, 2018 order. Now they cannot take that plea, that 2013 Act, the state is bound to assess without assailing that order. This is my respectful submission.
Yes.
I have not placed the affidavit of my learned friend. Let him place.
My lord, in this case, my lord, main thing is that is the judgment of the coordinate bench on that scandal. That is case 39. After, my lord, after the judgment, my lord, he can't say anything within the periphery of the this judgment, my lord, he can go, and we must also, my lord, bound to go to follow this judgment.
Yes.
Only for this clause, my lord, I want to read this judgment first, my lord. He can't say anything. My lord, inevitably the land of the petitioner, that is page 39, if your lordship see the judgment of the coordinate bench, we must follow and comply this judgment. He can't pray anything beyond this judgment. And we must, my lord, comply this judgment. According to us, my lord, we have complied. I have shown your lordship. Indubitably, the land of the petitioner, measuring more or less Ato, Samipur, and utilized by the Kolkata Metropolitan Development Authority, KMDA, for construction of the Prince Anwar Shah Road connector way back in the year 1980. The petitioner was deprived of the use of the enjoyment of the said property since such time without having been served with any notice of requisition under Act 2 of 1914. Neither the KMDA as the requisitioning body ever approached the state for acquisition until the year 2006, but continued to occupy and utilize such plot of land for such purpose. On the other hand, the state appears to have been passed the responsibility from one shoulder to another, and lastly took a technical plea that unless the proposal is routed through a proper channel, the request from the requisitioning body cannot be acceded to. The aforesaid stand appears to have been taken on October 25, 2011, whereby and whereunder the Chief Executive Officer of KMDA was informed that they are required to submit a proposal as per guidelines mentioned in GO number ATO with a copy of the cabinet note and a copy of the approval of the cabinet. The fact remains that no proceeding was ever initiated. I may not want to. No. But then that paragraph I may not want extraction of the rule. The next paragraph, on the basis of the undisputed fact, there is no doubt in my mind that an individual has been deprived of his property without recourse of law, and to undone such constitutional act, the property is required to be reverted back to the owner. But this court cannot overlook the fact that such property was required and utilized for larger public purpose and for construction of a connector facilitating the citizen of the city to have smooth and more convenient journey from different parts of the city. That is very important, my lord. Why we may not want to that revert back. Two processes that first or revert back, or you can pay the money. This court finds that the possession of the land to the petitioner cannot be given to him as the situation which is relevant at present renders it irreversible. Since the KMDA as institutional body has been informed to make a fresh proposal, this court permits the KMDA to make a fresh proposal within 4 weeks from the date strictly in terms of the rule guided of the. My lord, other proposal, my lord, is invalid. Now, be guided by this proposal. You must file a proposal. Whatever proposal you have done, that is not be done, taken in course of this, my lord. Only you must file this proposal. Now, my lord, the state is directed to take recourse to acquisition for the property as per extent guidelines. My lord, my learned friend, my lord, told your lordship this, my lord. I once again, my lord, I must read this. As because, my lord, this is very important. That is my learned friend of the petitioner, my lord. My lord, every time wanted to submit before your lordship that they will get more money, much money. That is the money, my lord. This state, the honorable court, my lord, specifically state the state is directed to take recourse. What recourse? Acquisition of the property as per the extent guidelines. And it goes without saying that the entire exercise shall be completed within 8 weeks from the date of the. My lord, that is why this line was there. At that time, my lord, 2013 Act has already, my lord, in the state, my lord. But as the rule was not there, up till now, rule was not framed. For that reason, my lord, our honorable judge, my lord, was very kind to us, my lord, to read this, to pass that order. The state is directed to take recourse to requisition of the property as per extent guidelines. My lord, as at that time when the order was passed, there was a guidelines. For that reason, my lord, acquisition of the property as per extent of guidelines. And it goes without saying that the entire exercise will be completed within certain time. So, my lord, my learned friend said, I get 2013 Act as per provision of 2013 Act. I get money as per provision of 2013 Act. Or I take the money that is the market value and 100% solar scheme. That is my learned friend, my lord, stated in the and showed that I can get it. My lord, there is a specific binding, not only me, my lord, but is the binding on the part of the petitioner. Petitioner can't get or say, submit anything that I must get otherwise. He must get within the purview of this phrase, my lord. Though this court finds that this direction has been passed to mitigate the situation and to secure the ends of justice, yet this court cannot brush aside that the petitioner has been deprived of his property without the payment of single. My lord, explaining this. After that, my lord, that is, my lord, explanation was there. Why that paragraph was there?
No, Mr. Dev, what is the wordings of the learned coordinate bench? Let me read side by side. Make a fresh proposal, KMDA to make a fresh proposal within 4 weeks from the date, strictly in terms of the extent, rule, guideline, or act applicable in this regard.
Extent guidelines.
Guidelines or act applicable in this regard.
Yes,
so, what is your view? What would be applicable in this case?
That is the guidelines. That is our guidelines.
Not the act.
As per, no, my lord. As my lord, at that time, there was act. My lord, now, if your lordship was pleased to pass an order, if he was to, that, no, I may not want to pass the order according to the guidelines. I must pass the order according to the provision of 2013 Act. Your lordship will pass specifically in that fashion.
No.
Not in this way.
Okay, in this order, it is that to the extent rule or guidelines or act.
Rule or, that is the, my lord, rule.
Rule
was
guideline.
framed, as rule was not framed.
So it is the state who can opt anything, either rule, guideline or act. So the state adopted the guideline.
Yes, my lord.
Okay.
After that, my lord, that is for the clarification is that, my lord, next paragraph.
is the clarification. The land acquisition collector, South Chobis Pargona, is directed to determine the rent compensation. Now, this is very important, my lord. My landlord said, I can get damage, I can get omuk, I can get tomuk. No, nothing else. You must stop. My
Okay,
lord.
rent compensation.
Only rent compensation. If your lordship, if my lord was pleased to pass that order, that rent compensation and damages and other things, we are bound to give them damages also in with the rent compensation. But he has not any right to ask that. He has not any right to show any order or judgment with this, my lord, that is the I must get the damage and other things. That is a restricted order passed, my lord. There is a restriction.
Only rent
Like
compensation.
that. Yes, my lord. Only rent compensation according to the provision of law. My lord, your lordship will see whether rent compensation which we assess, that is in accordance with the provision or not. My lord, if any dispute arose, your lordship will not, my lord, that will go, he must go to the district court. If he wants to say anything, my lord.
No,
Now, my lord.
No, how you assess the rent compensation?
Now, my lord, I am coming.
Okay.
I am not at that stage, my lord. I am not. My lord, in this matter, my lord, it is not possible for if your lordship is. My lord, only I take that paragraph, my lord. Directive to determine the rent compensation from the date of possession, my lord, that is the specific date. Rent compensation from the date of possession till the date of acquisition of right, title, interest by the state, and say, my lord, only rent compensation from the date of possession to Ato, and my lord, 6% per annum. The said land acquisition collector shall complete the rent entire acquisition within 8 weeks from the date of communication of this. I submit before the lordship, my landed friend can't go beyond, can't go, my lord, beyond this paragraph. Now, my lord, I am coming with the.
এখন আর coming হবে না, এখন
going
coming হবে না,
হয়ে গেছে।
এখন going
কথায় আছে সম্মান করে শেষ করে দাও।
হ্যাঁ? কতক্ষণ লাগবে তোমার?
অ্যাফিডেভিট তো প্লেসই করেনি।
স্যার, আমাদের মামলাটা শেষ হয়নি।
শেষ হয়নি, শেষ হয়নি।
শেষ হয়নি, স্যার।
শেষ হোক, আসুন তো জেলে।
এই সুললিত ভাষায় বলবেন, আমি উঠে যাবো, চলবে।
Few minutes for another day.
Except Friday, any other day, if there is slot is available. Now the problem is availability of the slot.
Yes. So 26, 27 is the next week.
Why don't you be going back?
Thereafter going to the circuit.
We are ready for Monday also. I am subject to my lord's.
No, Monday would be there and other. Everything is 3 and 4 matters are pending for part matters.
চালু 76 সাল থেকে আপনি এখন
আরম্ভ করলে না হলে বেশি করতে হতো না।
26
কটা?
26
27 সামনে সপ্তাহ আছে।
সামনে সপ্তাহে।
সামনে শুক্রবার।
26 মিনিট I have some day. আমার তো কেউ থাকবে না।
আমার শুধু দুটোই ফিক্স।
next Thursday.
Or after return of your lordship.
Out of mind.
আরে 26 তারিখ হয়ে যাক না, কেন?
ঠিক আছে, আমি আমার অসুবিধা আছে সেটাই বলছি।
তোমার আর বলার কি আছে? আমার তো বলা শেষ হয়ে গেছে।
এত ভালো আর্গুমেন্ট করছো, আমি উত্তর দেবো না কি?
আরে ওর তোমাকে বলি
27 12:30.
Yes, my lord.
Argument on behalf of the
27
on behalf of the state authority. Continue. Let the matter appear in the list on 27 at 12:30. As a specially fixed matter.
Right.
1 hour is sufficient.
Well, এক second, follow এক second. Is the lordship necessary to give a note subject to my lord desire?
Let him complete. Let him complete entire matter to complete.
না
আগে নোট।
No, this matter.
Yes.
Ratan Agarwal.
Yes. It was fixed.
Who is for the petitioner?
I'm for the response.
What is the matter?
This is with regard to a conversion charge which cannot be asked by ADDA pursuant to their own admission, or they have asked for conversion to the tune of rupees 81 lakhs. And they have already taken 27 lakhs since last 7 years. They are sitting tight over the matter. Very short point is there, my lord. Kindly take up the matter on Monday. My lord, any very short point. Mr.
Monday, Tuesday, Wednesday, not possible.
Then, my lord, 26. 26. Any day, any time, 26. Anytime, my lord, anytime. Anytime. Very short matter, my lord. No slot.
Original side is running busy, slot is there. Original side running with several arguments. Mr. Agarwal arguing a matter long.
26.
Everybody is long, only I am precise. So I give the certificate to me.
12, 30 anytime.
No, 12:30 not possible. 26.
Acquisition Act. Yes. Acquisition Act. আমাদের নেতা নেই এখন অন্য পার্টি উকিলদের নেতা নেই পুরো পার্টি হ্যাঁ কোথাও উকিল এখন খালি লিস্ট দেখে 48 লাখ ওটা পার হলো এখন
10:30. হ্যাঁ 10:30.
26, 10:30.
Oblige.
What the situation, huh? Bah.
Oblige.
It would appear on 26.
Your lordship will pass one line order. This is fixed on 26.
Not necessary. It would appear.
লেটার হলে লাগতো উনি তো অর্ডার হতো একটা
second half a group one
Yes, call the matter.
Yes, on the last occasion, I was making my submissions in respect of project escalation and loss of income.
Loss of income.
Both are on account of damages only. Only I was not able to convince your lordship why I have suffered, how I have suffered, and how I'm entitled for these damages. So in that connection, may I once again place the arbitral minutes before lordship. 11.
You have already placed the minute?
Yes, I have placed. That is 1582 and 1583, 1584. In that, the arbitrator was fully aware of my indemnity clauses, specifically clause number 19 and 27 of the agreement. I would like to place that 27 once again before lordship. At page 122, volume 2, our petition. Petition volume 1, 2, दुटे दे दें. Page number 123, 123.
Yes.
I am relying on clause number 27 of my agreement. The sub-licensee shall indemnify, defend, and hold harmless the licensee from and against all liabilities, damages, loss, expenses, and claims of any nature whatsoever for personal injury and for damage or loss of any property arising out of or in any way connected with sublicense performance of the sublicense. Now, it is an admitted fact that there has been a serious default in payment of license fee as well as other charges by the respondents. That is on record, Mila. Then I will also place para clause 19 of my agreement at page 122, Mila. The last portion of 19 I will place, which is relevant, Mila. In case licensee condones the default of sub-licensee, that is in respect of payment of license fee, then and in such event, the sub-licensee shall along with such dues and or arrears pay compensation for the loss and or damage suffered by the licensee and also interest at the rate of 1.5% per month for the period of default on all amounts remaining undue. Simultaneously, I also place section 73 of the Contract Act. আছে কি?
Yes, proceed. दिए थे? नहीं, please. Yes, 73. Compensation of loss or damage caused by breach of contract. When a contract has been broken, the party who suffers of such breach is entitled to receive from the party who has broken the contract compensation for any loss. A very important word is any. Compensation for any loss or damage caused to him thereby. Thereby means the default by the respondents, by the sub-licensing, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. My claim for damages in respect of project escalation and loss of income is neither remote nor indirect. It is a direct. Compensation for failure to discharge obligations resembling from created by contract. When an obligation resembling those created by the contract has been incurred and has not been discharged, any person injured by the failure to discharges is entitled to receive the same compensation from the party in default as if such person had contracted to discharge it and had not broken. I have very categorically stated before your lordship as well as before the tribunal that had the payment of license fee and other charges been paid to me, I would not have made such claims. Yes, you have argued, Mr. Surana, that point.
Yeah. So what I wanted to submit, my lord, here, I
You have submitted that your acceleration cost of rupees 75 lakh is
75
for the
crores.
projects, other two
75
projects.
crores.
75 crores.
Yes, my lord.
For the other 75 crores.
Yes, my lord.
For other two projects, which you could not
My lord,
complete.
what I wanted to humbly submit, kindly have a look at page 30 of volume 1. Volume 1. Annex documents. Documents. Volume 1. Page 30.
Yes.
But this is my project. This is on one project, my lord. There I am constructing various buildings. Building A, I have named that building A, building B, building C. Now building B was sub-licensed to them. Now all the premises are within the same complex. The complex is known as Puja complex. The entire area has been given to me for commercial development by the railways, my lord. So this is not a different project located outside. This is one project only. Maybe a different buildings are there. Maybe different agreements are there. And the statute very categorically says, in the event of default, if I suffer any loss, I am entitled for that. It's not a different building, my lord. It's the same complex. I'm located in the same complex.
I have already stated you earlier that the entire world of loss is not for you.
No,
for the damages.
What I want
for the fault of the other party. Not for the entire world.
My lord, I
have to prove it.
My lord, that is what I say. I have submitted necessary documents also.
Yes.
How I have suffered. Those documents I will place once again, my lord. In the meantime,
you have already placed those documents before the tribunal.
Yeah, and before your lordship also, I'll just again remind that before that, my lord, I would like to place few letters which I have written to them. Then volume 3. Volume 3. Page 321. The second paragraph of this letter, my lord.
Yes.
We once again request you to kindly make the payment of proportionate costs for bringing the power from the board without any further delay, failing which you would be fully responsible for all our losses, including damage to the diesel generators. So I have given them a warning. They were aware of this. Then kindly come to page 322, my lord.
This is the cost of DG set you have already made.
My lord, including DG sets. I have said delay failing which you would be fully responsible for all our losses, including DG sets.
Yes.
All losses covers whatever loss I am suffering, my lord. Then kindly come to page 322. My lord, these letters to a tenant or to a sub-licensee has to be written in a very simple manner.
No, it is not so simple you are arguing. You are not covered for all the world of loss is not covered.
My lord, I am suffering my loss in the same
Yes,
project.
you have suffered a loss of say one rupee.
Yes,
1 rupee due to their default.
My lord.
So you may have lost 50 paisa in other project. That is not connected with your
This is exactly what I'm trying to impress upon your lordship.
Is there any connection that if I want this clause only in the agreement, if you fail to pay the license fee, my other project will hamper. Is there anything?
This is what I wanted to humbly place before your lordship. That neither the statute says that if it is a different loss is suffered in different project or elsewhere. It is not there. The statute says if there is a default, if I suffered any loss, I'm entitled for that.
But that shall not be so remote.
My lord, I will place my submissions before your lordship. It is up to your lordship to assess that.
Yes, that's why you have argued on that point. Again, why you are arguing?
I am just placing these letters so that I have made them known that if you do not make payment of license fee to me in time, I will suffer loss. And these agreements were well aware. They are well aware of these agreements. And even if, my lord, even if these agreements are not considered, the interim award was passed on 8th of April 2013 for eviction. I was entitled for, and they have said it was a consent order. It was a consent. They should have delivered the possession. They did not deliver with the possession. They have leased it out at 40, 45, 50 rupees to other dealers, to other franchises. Had I got that, I would have been able to earn that money, my lord.
That you can.
That
you can.
That is.
But why you mixing this? Your other project and cost of other project would be they are liable to pay.
Why I'm mixing?
You are very well can ask for that. That is that you have already argued.
I have argued.
You have already,
and I have left the entire thing to your lordship. What I wanted to submit that because of their default in payment, I have suffered loss. Now it is my duty to place before your lordship the quantum of loss which I have suffered.
Okay.
And I have placed necessary documents before your lordship that these are the documents. If your lordship is prepared to accept my documents, my submission, I am entitled for that. Else it has to be decided.
You have also placed those documents with the arbitrator.
Yeah, all the
yes,
all these documents were there, and these letters why I'm placing before lordship that I have made them known.
Okay,
that this is
there are several letters you have.
Yes, my lord.
You have
like
already
321
informed them that I am suffering loss. I am suffering huge loss like that.
Yeah, my lord. 322 also.
322.
Yes, my lord.
Yes.
With reference to the above agreement, we wish to inform you that you are liable to bear the proportionate cost of bringing in regular power supply from the board. We have, in terms of the above stated agreement, communicated you several times to make the payment of proportionate cost to enable us to bring the power to the project. Although you have assured to make the payment, it is regretted we have not yet received the payment, causing us huge loss on development of the project. Now, if I said development of the project, Entire project is covered, my lord. They were known, they were made aware of this. It's not that they were not aware of this. The development of the project, not of the premises, not of anything else. Yes. Kindly come to page 325, my lord. Three 25. Yes. Paragraph 3. In terms of the agreement dated so and so, you are liable to bear the proportional cost from bringing power to the power from the board. It is regretted, in spite of our repeated requests and reminders, you have not come forward to bear the proportional cost and pay us the proportional cost, thereby, thereby delaying the supply of power by the board. This is causing a serious financial loss and loss of faith and loss of goodwill. Now, my lord, the power was for the entire project, not only for them. It was for the entire project. Then again, my lord, another letter 355, my lord. Again, here paragraph 3, my lord. In the circumstances, you would find that you have consistently and regularly, without any fear, committed material breaches of the said agreement, thereby causing damage and loss to us. You have stated to terminate the agreement forthwith without honoring the terms of the agreement. We shall have no hesitation in accepting your termination of the agreement, provided you come forward and clear all our outstanding dues stated above and make good all our losses and compensate for our damages. Yes. Next page, my lord, 356. The second paragraph, my lord. As you are aware, we have incurred substantial expenditure of over rupees 50 crores for the development of this complex. I'm not saying only one project, of the complex, my lord, which had to be suspended owing to failure of your making the payment of proportionate cost. Now I am saying has been suspended owing to the development work in the project has been suspended. I have brought it to their knowledge. For bringing power supply and your continuous failure to make the payment of license fee and other charges in terms of the agreement, and reasoning and unwarranted recoveries every month from the payment of license fee to our so and so monthly payment from July 2010. The last payment was made by them in the month of July 2010. Thereafter, till date, my lord, there has not been any payment. In view of our continued material breaches on your part to comply with your obligations under the agreement, compelling us the suspension of the project work, have suffered and continue to suffer considerable loss and damage. So I have categorically informed them that because of your default in payment of license fee and other charges under the contract, I had to suspend the development of the entire project. They were made aware of this. Okay. In this connection, my lord, may I also refer to a judgment delivered by the Honorable Calcutta High Court in Apijay Private Limited versus Steel Authority of India Limited. This is a judgment delivered by Justice Soman Sen.
Yes.
On the first page, my lord, the claim in the arbitration proceeding is on account of damages suffered by the respondent claimant due to failure on the part of the petitioner herein to take delivery of 8,990 metric tons of finished iron slabs under a contract dated 8th of April 1960. Hindustan Limited, now known as Steel Authority of India Limited, initiated the arbitration proceedings against the respondent partnership firm, claiming a sum of rupees 15.7 lakh on account of loss and damage for breaches of the contract dated 8th of April for sale and purchase of steel slabs. The claimant under the contract was to buy 25,000 metric tons of slabs for sizes and specifications given in the said agreement. The agreement mentioned the terms and the dates of delivery, price payable and payment to be made, inspection, weight, test certificates, etc. Thereafter, the parties mutually agreed to amend the said contract inter alia by extending the date of completion of the sale of the contract quantity up to 31st March 1961. The price and payment clauses of the agreement were also suitably amended. The contract also stipulated that under the barter agreement with the iron and steel controller, that the entire amount of dollar and pound earned by the export of these steel slabs shall be utilized by the respondent firm for import of finished steel materials as per the stipulations of the iron and steel controller. The claimant on different dates had delivered to the respondent total quantity of 16,161 tons of steel slabs up to 14th of April 1961. In spite of repeated requests of the claimant, the respondent did not take delivery of balance 8,990 metric tons of the contracted materials which were lying at Visakhapatnam port. The contract was for 25,000 tons.
Yes.
And they have taken delivery of 16,000 tons. The remaining 9,000 tons they did not take. The claimant in their statement of claim averred that they obtained permission to sell the balance quantity either by private or auction or by tender from the iron steel controller. The claimant had published sale notices inviting offer for purchase of the said materials at the port of Visakhapatnam. They had sold to the highest bidder 9,000 tons of steel slabs which were lying undelivered at Visakhapatnam port and realized rupees 26 lakhs. By the said sale, they suffered a loss of rupees 10.43 lakhs, being the difference between the contract price and the price at which the said slabs were sold. The contract for supply to was with the Apijay, and they have disposed of the materials to somebody else. Thereby, they have suffered a loss of 10 lakhs. The claimant also claimed from the respondent a sum of rupees 5.96 lakhs for the damages set out in clause A to D of the paragraph 39 of their statement of claim towards the ground rent paid to port authorities for stacking and storage charges, cost of shifting and materials, etc., cost of guarding, lighting and alternative guard and security materials, and interest by way of damages which the claimant would have earned on the price of the said goods had such price been paid. Now, all these things were outside the contract, Miller. When the contract was entered with Apijay, these conditions were not there. The claimant, before the arbitrator, had prayed for an award of a total sum of rupees 15.79. Now, this includes 10 lakhs which they have suffered by disposing of the materials, and another is 5.96 on account of damages, which includes interest, this charge, that charge, and all this. Now, it is also stated here, my lord. Kindly come to page 25, my lord. I'm sorry, it is not stated. Page 25. Has it been paginated, my lord? It is there then. And the details of the entire claim is stated here, my lord.
Yes.
The 3 pages, the 3 paragraphs relied upon by Mr. Carr of the statement of claim, namely paragraph 39, 40, and 41, and the payment clause have been duly considered by the learned umpire by reference to the decision cited by the parties in this regard. 39. The HSL also claims the following sums as damages from the respondent. Rupees 21,500 ground rent. Rupees 13,221 cost of shifting of materials. Rupees 22,000 spent by the HSL for guarding, lighting, and otherwise ensuring the security of the said goods. And rupees 4,78,000 the amount of interest the HSL would have earned on the price of the said goods. Further, a better particulars of damages claimed appear from a schedule here to annexed and marked C. In the premises aforesaid, the HSL states that it has suffered loss and damages which is assessed at rupees 15.79 lakhs. ABC 1 to 5, the details have been stated over here, my lord. By letter dated December 2, 1963, the HSL demanded from the respondent the said sum of rupees so and so, but by its letter dated so and so, the respondent wrongfully refused to pay the said sum or any portion thereof. The respondent has not paid the said sum of rupees so and so, or by any particular thereof of any other sum or so and so. Then page 30, my lord, I will be referring the last one page.
Yes.
The second paragraph only, my lord. The reasonableness of the reason cannot be gone into in these proceedings in as much as interpretation of the terms of the contract, including the decisions and authorities cited before the arbitrator, are within the exclusive province of the arbitrator, unless, of course, it is demonstrated without battering of an eyelid that the decision is contrary to the law laid down in those decisions. My humble submission is I have placed all the documents before the learned arbitrator, and there has not been any adjudication on that. Simply by giving any damn reason, these have been rejected. So here, my lord, the damages have been suffered not under the same contract, has been suffered otherwise. There was a contract for 25,000 sold to this gentleman. He lifted only 16,000 tons. 9,000 was left over there. That was sold to some third parties. How many parties were there? It's not stated. But by disposing of that, they have suffered a loss of 10 lakhs. They have suffered interest. They have suffered this ground rent. They have suffered guarding and all this. All these claims have been given and it has been accepted, my lord. It has been accepted by the Honorable Court also, my lord. The last 31 page, the application for setting aside of the award being so and so stands dismissed. However, there shall be no.
Yes.
And like that, my lord, the judgment of Kailashnath is also there. It is between DDA. Now, DDA wanted to sell certain projects, certain plots. They could not because of certain clarifications from the government. The government gave the clarification. By the time they have refunded various sums to one of these parties, Kailashnath, they could not refund. Their advocate wanted that the refund, the earnest money should be refunded with 7% of interest. Court says no. You have sold those plots at a higher rate. You must pay 9% interest.
Yes.
So it was also beyond the contract, my lord. So my humble submission is, if by breach of a contract, if I suffer any loss, I'm entitled for that. And I'm here to explain to the tribunal and to your lordship also that how I have suffered. Now, arbitrator, I have placed all the documents not considered. Award has been passed contrary to the evidence. No adjudication. Okay. And as far as this project escalation is concerned, my lord, what has been stated by the arbitrator Kindly come to paragraph 82 of the award, my lord. Volume 180. Page 99. Petition, volume 1.
Yes.
Page 99, my lord. Paragraph 82. Can I place it, my lord? This is in respect of project escalation, my lord. This claim is made on the basis of a less fact that the claimant could not complete the project due to the respondent's failure to pay regular license fee and other breaches of the agreement by them. Whatever I am placing before Lordship, the same was placed before the tribunal also. The absurdity of the claim is apparent from his averments contained among others in paragraph 49 of the statement of claim. Reading the agreement as a whole and even reading between the lines, it is inconceivable to include that the respondents had ever assumed the liability or otherwise agreed to finance the project. I have never said that you finance the project. I have only stated you must make the payment of my license fee and other charges according to the terms of the contract. I don't know how the learned tribunal has come to a conclusion that I wanted respondent to finance my project. And it was not my case, my lord. This could not have been the intention of the parties at the time of entering into the agreement dated so and so or since then. My lord, nowhere in the agreement your lordship would find that I have sought financing of my project by the respondents. Nowhere.
That was stated. That was mentioned here.
Yeah.
Respondent had ever assumed the liability or otherwise agreed to finance the project.
So I say this is contrary to the agreement. I have never said so.
Yes, that is the averment of the arbitrator. That is agreement doesn't say that the financing would be given.
Yes, ma'am.
That is not. That is the.
Mr. Surana, in course of his argument, sought legal support of his claim from clause 27 of the agreement.
Yes.
By the said clause, the respondents at best seem to have assumed the responsibility to indemnify and hold the claimant harmless, limited to the personal injury and loss of any damage to any property. So, learned tribunal was fully aware of my clause. This is a commercial contract, my lord. It has to be decided from commercial angle only. No, it should not go against the principles. It should not go against the statute. It should not go against the law. But a commercial contract is a commercial contract. I have placed before your lordship various judgments that a commercial contract should be decided from commercial angle on. And the intention of the parties have to be looked into. My intention was, they were aware of my intention. I have brought it to their knowledge by writing various letters also, various discussions also, that if you don't pay, I will suffer, and if I suffer, you are liable for that.
Okay.
Even if I could be persuaded to hold the said clause 27 was intended to have such wide import, I would hold the said clause as penalty clause. My lord, penalty clause is altogether different. At any rate, by no sensible view of the facts, one can hold that failure to complete the project by the claimant and the resultant loss was in any way attributable to the respondent. The claim is therefore not covered by the said clause. The claim is patently untenable, speculative, and vexatious. I therefore do not intend to deal with the equally absurd arithmetics of the claim. The arithmetic was, my lord, I have placed before the tribunal what was my cost of construction in 2005 and what was my cost of construction in 2005. One has to calculate. To avoid that also, I submitted a letter of an architect approved by Calcutta Municipal Corporation that what was the cost of construction in 2005, what is the cost of construction in 2005. I also produced before the lordship the schedule of rates of PWD and CPWD. Now this is a civil work, my lord. Every big organization, every big department of Union of India or state government, they have a schedule of rates. It could be easily verified. It's not that I'm demanding something unique, something different.
No, you just do not understand the contention of the arbitrator. Arbitrator says that whether your loss in the other project is ever connected with the agreement.
This
has to be proved.
Yeah, this is exactly what I'm saying, my lord, that I have made the
You must have made some law, you must have suffered some loss. You could not raise the project. But whether this is come under the agreement,
They were made aware of that. They were made aware
they
of that.
were make aware of that
Yes.
later on, but at the time of making agreement, whether this was the clause.
No, my lord. Then kindly have a look at 73, my lord, once again. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course, of things from such breach.
Yes.
Now, this has arisen from their default
No,
only.
this is the usually breach. What you have seen, what you have cited this judgment.
Yes, ma'am.
Because this iron seat was lying there, the person has to guard it, otherwise it would be stolen. These are the natural course. That is the natural course. But you have started one project and you have intended that from the getting such license fee, I will able to complete the project within a time. But it was not completed due to their fault.
This is exactly what I'm trying to impress upon your lordship. Which naturally arose.
Yes, naturally arose. This
Arose
is naturally
in the
arose.
usual course of things. What is the usual course of things? Had they not defaulted, would I have made this claim, my lord? No, I had no authority. If I cannot develop, it is my bad luck. But why I could not develop, I have explained to them. I have written them various letters. Make the payment, otherwise I had
Yes,
to
Mr.
suspend.
Surana, I understand your submission.
My lord. Yes, Mr. Surana, proceed. And as far as this concerned, just 1 minute, my lord. 80. That railway letter is that it is very difficult to understand. This is what has been stated there. This is a simple calculation, my lord, at page 622, my lord. Page 622. Now, this letter was disclosed before the tribunal, my lord. Here, the railway has very categorically stated that I have got the permission to develop 10,615.89 plinth area and G plus 4. So it has to be only multiplied by 5 only, nothing else, my lord. And which is the simple calculation, my lord. I have just multiplied by 5 and have come to the total area what I was entitled to construct, my lord. This is 10,615 into 5. It has come
What
to
is
5.
This is the development of the area.
Yes.
Area development, that is the square meter.
Square meter is 53,079 or 5,71,347 square feet.
This is the area you wanted to develop.
Yes, I was authorized, I was entitled. Railway has granted me permission to develop this in the same premises, in the same plot of land. And I have told them that if you don't pay me, I had to suspend my development.
Yes.
And this letter is disclosed before the learned arbitrator, may not at page 622.
Yes. I hope, my lord. Yes, proceed. I hope with my little knowledge I have been able to explain my grounds for project escalation.
Yes,
as
I
well as
understand.
something. Now the next is, my lord, clause item number 14, charges for parking of terrace space.
Paragraph 48.
Yes, my lord. Paragraph 84 of the award, my lord.
84.
Yes. It starts from 100, my lord.
Yes.
The small one paragraph only. There is only a passing reference to these two claims in paragraph 40 of the statement of claim without disclosing any ground for such claim. The computation and support to be found in annexure F is equally bald and bereft of details. I reject these claims.
Where is the computation? What is the
687. Page 687. Volume 5. Volume 5.
what are the agreement?
My lord, the agreement was
Yes.
the agreement clause is at page 118, my lord. Roman 8, my lord.
Roman 8.
Yes. Can I place it?
Yes.
The licensee shall not charge any car parking charges from the sub-licensee's customers.
Shall not charge any car parking charges from sublicense charge.
From the customers. Now, my lord, it's a use area which was sub-licensed to them around 1,15,000 square feet.
Okay.
And they have their employees were bringing a lot of cars, lot of bikes, lot of scooters, lot of cycles. They wanted a space for parking of them. I have provided certain space in the ground floor. The worst is, my lord, that they have executed an agreement. R2 has executed an agreement with R4. Respondent number 2 has executed an agreement with respondent number 4, Future Value Retail Limited. That agreement was never disclosed before the arbitration. This was not disclosed even in their section 34 petition. In that agreement, my lord, they have started claiming parking charges from the customers. But this is my area, my lord. I have provided them for free parking of their customers. How can they charge parking fee from the customers? And they were earning something around 3.5 to 4 lakhs a month without paying me, without anything. No, I'm not even claiming that. What I am claiming, I have provided certain amount of areas to them for parking their own cars, own scooters, own vehicles, own cycles. They need certain areas. I have provided them. And then kindly come to page 687, my lord. This is an admitted document, page volume 5, 687, my lord.
Yes.
Can I place it, my lord? We find from our records that payment of license fee for the puja
the Mega Mart sub-license to you by an agreement dated so-and-so is not made in terms of the said agreement. This is incorrect. You are only authorized to deduct TDS from the payment of license fee and nothing else. You are also required to pay CAM charges at the rate of rupees 150 per square feet and other charges like water and electricity charges in terms of the agreement. Our site engineer, Mr. N.K. Ghosh, has reported that you are parking your vehicles, scooters, bikes, cycles in the premises. We wish to inform you that under the contract conditions, we have permitted free parking of cars of your we have permitted free parking of cars of your customers only. You would be required to pay necessary charges for parking your own vehicles, scooters, bikes, cycles in the premises based upon space used, which may please be noted. You have desired certain space on the terrace for provision of some equipments, machines in relation to your food court. We have provided the space on Mr. Sandeep Marwa's confirmation to make the payment of rent for the same. We once again request you to expedite the payment of proportionate share of bringing power from the board. Mr. Sandeep Marwa has informed the undersigned that he has requested Mumbai office for prompt payment. Now, my lord, I have communicated to them that I will be charging, and this communication has not been disputed. Subsequently, I have communicated to them that I will be charging 2 lakh per month and 25,000 for the terrace space, which is even less than the license which I have been charging. They have opened a food court over there for certain equipment. They wanted some space for installation of certain machines over there. I have allowed them. And then their witness has also categorically stated we are liable to pay for that. Whatever areas we are consuming, we are liable to pay for. So this is an admitted document where I have said that I will be charging number one. During the course of business, I have communicated them that I will be charging so and so. There is no denial for that. And then their witness is also accepted. I'll just place before your lordship the relevant portion also. जो 1404 है वॉल्यूम 10 yes. The payment of letting out such a space was confirmed by the regional head of the respondent number one, Mr. Sandeep Marwa. The chargeable area was jointly determined as 12,500 square feet for parking of their employees' vehicles, scooters, bikes, and cycles, etc., and 1,800 square feet for installation of the equipment on the terrace. Thereafter, it was mutually agreed that the charges for such car parking area would be rupees 2 lakh per month and rupees 25,000 per month for the space on the terrace. Mr. Sandeep Marwa, regional head of the respondents, has stated that since requirement of such a space is post execution of the agreement, his confirmation of the aforesaid charges license fee would be good enough for his office to make payment. He further stated that he would keep the head office informed of such charges license fee to be paid to the petitioner. Now, this was post-agreement, my lord. The learned arbitrator in minutes of 63rd sitting had stated that I have already observed the basis of items of counterclaims has not been explained, nor has the said claims been computed. I therefore do not think it necessary to record the submissions of Mr. Surana, the claimant, in greater details. The learned arbitrator also ignored claimant's submission that the respondents are realizing parking charges from the customers from the parking area which was allowed to them as free parking zone as per clause D6, D7 at running page 118 of the petition. Thus, it is clear that the submissions made by the claimant petitioner in support of his claim have not been recorded in greater details for the reasons recorded by the learned arbitrator. Now, the acceptance of the respondent for payment of such additional space could be seen from the cross-examination of respondent's witness, Mr. Anil Cherian, when he agreed to pay for such space and clearly confirmed in his answer to question number 174 at 1404, page 1404, my lord. Question number 174, absolutely bottom, my lord. Yes. Have the respondents made payment of electricity charges for the area on the terrace on which the exhaust system was installed? Chargeable area under the agreement is determined by the parties on joint measurement. The exhaust system is a part of the infrastructure of the mall. Respondents are liable to pay the license fee only for the chargeable area determined in terms of the agreement. Now, the earlier measurement was for the area which was sub-licensed to them, and the subsequent, it is subsequent. So it was whatever their regional head has said, we have accepted, and the regional head has said, Mr. Surana, no requirement. I am confirming to my accounts department, and you will be made payment for that. Now, in commercial transactions, we have to accept certain, we have to give certain amount of accommodation. We have to accept such commitments also, some understanding also. What I wanted to humbly submit that the witness has not disputed this, that it is payable.
He is disputing that only the license fee is included, the everything that is the exhaust,
But this is exactly
all the infrastructure of the mall.
This is what exactly I'm saying. If your lordship would come to page 108, which is the measurement, that terrace is not there, my lord.
Yes.
Right? This is a subsequent. So now he has agreed that whatever is the area, I am liable to pay. Other he could have disputed, I have not taken anything on the terrace, my lord.
Now, what he answered, chargeable area under the agreement is determined by the parties on joint measurement.
Yes, my lord.
That is the first measurement.
Yes, my lord.
The exhaust system is a part of the infrastructure of the mall.
So he has accepted this?
Yes.
Yes.
Respondents are liable to pay the license fee only for the chargeable area determined in terms of the agreement.
Yes, my lord.
Not beyond that.
Now, what I wanted to
He
say
is not
that
agreeing.
This area is post agreement, my lord. This subsequent area is post agreement.
Yes.
And this subsequent area is post 108 measurement also.
Yes.
And their regional head has said, Mr. Surana, I am confirming to my Bombay office, and you will be paid for.
Whether evidence he admitted that?
He could have denied that. He could have denied that. Number one. Number two.
Denying. He is denying no such measurement is not chargeable.
It's not that no such measurement. He says, I am liable to pay as per the measurement. And I have submitted before the lordship.
What he said, you just read it, not your way. What it was, read it was. Respondents are liable to pay the license fee only for the chargeable area determined in terms of the agreement, not beyond that.
My lord,
this is the answer.
The subsequent area was also in terms of the agreement.
Whether in there any question regarding subsequent area?
Let us forget about this. A simple question, my lord. 108 is the measurement, joint measurement, my lord. That does not involve the terrace area. That does not involve the parking area. One has to calculate what is the area. Maybe whatever minimum, 1 square feet, 2 square feet, 10 square feet. Something has to be there. And their regional head has said, yes, I will provide you. I cannot provide
Whether you have asked any question like that, is there any answer?
But my lord, whatever I have submitted and this claim, there has not been any contradiction on this.
No, I understand. No, I want to know whether you have asked him during inquiry.
I will check up and I'll come to know. I'll check up and will come to know.
Regarding the excess area. That is the post-agreement area they have acquired.
This is the post-agreement, my lord. He says that I am liable to pay as per the agreement. Now, he has also submitted that yes, we have taken this on the food court and all this.
You asked a question that whether you respondents are made payment electricity charges on the area of terrace. He said, no, terrace or the exhaust is the part of the mall.
Kindly come to 172.
Yes, question number?
172.
Yes.
Was there any exhaust system for the food court installed at the terrace? There could be.
Yes, he admitted.
There could be. He is not denying. Was the terrace included within the area which was given license to the respondents? The area under the agreement has been specifically determined and agreed by the parties. The document is a part of this proceeding. So the document is 108, not the other one. So he has agreed that we have installed certain material, certain equipment.
That means he has not answered the question properly.
He is a qualified chartered accountant or is a company secretary. Your lordship has gone through his evidence. Your lordship would come to know what is my question and what he has replied, my lord. My humble submission before your lordship is that 108 is the determination of area under the agreement. And according to the license fee is liable to be paid according to that. Number one. Number two, these things have happened post that. For that, there is no record, jointly measurement, this and that, and not there. The regional has said, Mr. Surana, this is not needed. We have agreed to that. And there is
whether they admitted that, they must have not denied.
They have not denied.
They have not denied, but whether in question they have admitted it.
My lord, I will check up and will come back once again.
That your employees are parking some their vehicle there.
My lord, this is my evidence is there. Affidavit of evidence is there. Can I place that my affidavit of evidence, my lord?
No, I want the answer. The answer of that party.
My lord,
You have put some questions.
My lord, if there is my evidence, affidavit is there. If I have raised this question, if they do not raise a question on that,
that is the on view is that
so what I am
legal position is there. I understand.
So what I want to say that this claim I have raised, say X amount, which has not been disputed by. They could have said, I do not agree. This is bad. This is wrong. This is not liable. You are not liable to be paid, and nothing is there.
Okay.
The only thing which your lordship has to consider that they have not denied that they have not taken this space. And Millard, they have employed around 500 people there. And around 40-50 cars they used to park. Around 250 bikes they used to park there. Around 150 cycles they used to park over there.
Why you allowed them?
Millard, the whole thing is they were the anchor stores. And I did not want to antagonize them because I wanted to develop this area in a bigger manner. Your lordship would probably...
You must have not allowed them without agreement.
This is my bad luck, ill luck, my lord.
Otherwise, the one new agreement can be...
My lord, what I wanted to say, these things do happen in course of business. If I can give an example to you, if your lordship would allow me, Tata Group, their chairman, they called me in their office. They said, Mr. Surana, sorry, managing director, not chairman, managing director. Mr. Surana, we want some business from railways. I said, okay.
They want some
business from railways. They were not getting business from railways or pig iron. I said, I'll look into that. I got them business for over 20 crores. I said, please pay me my remuneration. Mrs. Surana, there was no agreement. This is the performance you have shown that you are capable of doing this business. And one fine night, I wrote a complaint to the chairman. This is what your company has done to me. They have appointed a ex-general manager of Steel Authority of India to check my statement. Then their managing director called me, Mr. Surana, can we have a cup of coffee? Yes, my lord. I went to his office. He said, A board of directors meeting has sanctioned rupees 100 per ton to you. Please take it. I said, sorry, I can't take it. I want minimum 500 rupees. Mr. Surana, the board has considered, Tata board has considered. I'm sorry, they have to make another board meeting, either accept or reject. But I will not take it. After 1.5 months, they said, Mr. Surana, please come, second round of coffee. And I was paid 500 rupees. No agreement. So in course of business, a lot of things happen, Mila.
Yes.
And when the regional head says, yes, Mr. Surana, I will pay you.
You have to believe it. Okay.
So I have placed before your lordship various judgments that this is a commercial transaction, Mila.
Yes.
Paragraph 109 of the award, Mila.
Yes.
Your lordship will again blame me for this, Mila.
No, not at all. Paragraph
109. This was the arbitral cost, Mila.
Okay.
Cost of arbitration.
Costs. Yes.
Both parties have conducted the proceedings in a most irrational manner,
Yes.
resulting in a prolonged hearing. Both parties had given me to understand at the initial meeting that the hearing would be concluded within a period of 15 days. Unfortunately, the proceedings dragged on 82 sittings. Accordingly, I direct that parties should bear their own costs. Well, whatever time I have taken, an equal amount of time was taken by them also.
So cost was refused.
And I have paid them, my lord. I have paid to the honorable arbitrator, learned arbitrator, a sum of rupees 19,15,333. The arbitral remuneration of my share, 19,15,333. Apart from that, my lord,
yes,
I had to spend 93,500 on venue cost. If I remember distinctly, my lord, they have also shared that venue cost. And then I have spent around rupees 10 lakhs to my advocates. Up to 44th or 45th sitting, my learned advocates were there. Thereafter, I have conducted. So around roughly 30 lakhs I have spent on this meeting. This is only my share. And they have also, the remuneration is equally paid by them also, my lord.
yes.
And as far as cost is concerned, my lord, I am entitled for 31A, my lord.
Arbitration consideration.
Excuse me. Isn't it?
Yes.
Well, 31A is for the cost.
Yes.
And not take much of a time, my lord. The things are stated over there that I am entitled and I should have been paid. I'll place 31A, 2 and 3, my lord. If the court or arbitral tribunal decides to make an order as to the payment of cost, the general rule is that the unsuccessful party shall be ordered to pay the cost to the successful party. The court or arbitral tribunal may make a different order for reasons to be recorded in writing. 3. In determining the cost, the court or the arbitral tribunal shall have regard to the following circumstances: the conduct of all the parties; B, whether a party has succeeded partly in the case; C, whether the party had made a frivolous counterclaim leading to delay in the disposal of the arbitral proceedings; D, I have made a claim of something around some 255 crores and they have made a claim of 362 crores. Now, 362 crores, they have not pressed. The major portion they have not pressed. They have pressed only a license fee and loan of around some 3 crores and a small amount. Nothing else. And whatever I have claimed, I have stated these are the reasons why my claim is
Yes.
subject. So this is I leave it to your lordship, my lord. What I have paid, I have stated, and I am entitled with the cost of the arbitration. My lord.
Yes.
The next important is, my lord, payment of interest. For that, my lord, there is no page 109, my lord. Para 107 at page 109 of the award, my lord.
Yes.
Can I place it, my lord? By reason the following analysis of events and on the basis of evidence, both oral and documentary, I have come to the conclusion that the claimant was entitled to a total claim of 18.16 crores taken together all items of claims, while the respondents were entitled to an agreement to aggregate sum of rupees 5.26 crores on account of their claims for set-off and counterclaim. In this context, I wish to record that having regard to the erratic and irregular fashion in which both parties conducted themselves in discharge of their contractual obligation, be it payment of rent or repayment of loan, I found it practically impossible to calculate interest in any of the terms of claim or set off, notwithstanding provisions for paying interest was provided for in the agreement dated so and so, or in any other entered into by them since then. For allied transactions, having my estimate of damages, I have accordingly ignored. What is this practically impossible to calculate, my lord? This is very simple. The paying authority will calculate. That tribunal was required to pass an order. And my clause number 19 of the agreement is very particular, my lord, that I am entitled for 1.5% interest for any dues, and that interest will be calculated from the time it has become due for payment.
Yes.
So any award passed contrary to the terms of the agreement, contrary to the provisions of law, is bad and is liable to be set aside. And I have placed before the learned arbitrator some few judgments also, that since I have taken a loan from the bank is charging compound interest, I am also entitled for compound interest, although there is no such provision in the contract. Okay. Milan, in regard to interest, may I place one judgment? Either consulting And as far as interest is concerned, my lord, section 31 is very clear that it is to be paid 31(7)(a) and 37(b), my lord. And 37(b) has very categorically stated it is 18%. Subsequently, it has been modified. Now, in this judgment, my lord, yes, and rely on paragraph 33, my lord, at page 9.
Paragraph 33.
33 at page 9, my lord.
Yes.
Under clause A of subsection 7 of section 31 of Act 1966, I find that it relates to the power of arbitrator to impose interest in the first stage as mentioned here and above. That is from the date of the cause of action to the date of arbitral award. The said clause begins with unless otherwise agreed by the parties, thereby at the onset of the subsection itself, the legislature has provided for a restriction on the application of the said subsection. In the event there is an agreement between the parties to the arbitration regarding the payment of interest from the date on which the cause of action arose till the date on which the award was made, the terms of the said agreement would prevail over clause A of subsection 7 of section 31. That is what I am saying, middle 31(7)(a) and 37(b). Now B says B has been modified by an amendment in 2015. Earlier it was 18%. Now 37(b) reads, my lord. 37(b), can I place it? 31(7)(b), my lord. Yes. 31(7)(a), unless otherwise agreed by the parties where and in so far as the arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the arbitral award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part or part of the period between the date on which the cause of action arose and the date on which the award is made. Here it is very clearly 1.5%, very clearly stated. B, a sum directed to be paid by an arbitral award shall, unless the award otherwise directs, carry interest at the rate of 2% higher than the current rate of interest prevalent on the date of award, from the date of award to the date of payment. To that, my lord, he has very categorically stated that yes, I am entitled for interest at the rate of 18%. I'll just place that before. Paragraph 108 of the award, my lord. Yes. In the premises, I award a sum of rupees 12.9 crores to be paid by the respondents to the claimant Mahavir Construction. The said award shall carry interest at the rate of 18% per annum from the date of award till total sum awarded is realized by the claimant. For the sake of clarity, I make it clear that the awards against the respondents is against each and all of the respondents individually or jointly. Now, as far as this is concerned, my lord, I had filed an application for securing the interest also, my lord. The Honorable Court had passed an order for securing another 10 crores. Yes. They have filed as SLP. Unfortunately, they got an injunction that carried on. And on 10th of September 2024, an order was passed that since it has continued for so long, let the 34 sections be decided within 6 months. So my humble submission is interest has to be paid to me from the date when my sum has become due for payment. And as far as my cause of action is concerned, I was entitled payment of license fee every month, payment of CAM every month, payment of water charges every month, payment of electricity charges every month, and other charges, whatever it is, every month I was entitled.
Date of cause of action.
Date of cause of action. And date of cause of action, this is the payment of license fee every month. Every 10th day of every month I was entitled.
Date of cause of action to the date of award.
And from the date of award, he has very categorically stated, I am entitled for 18%. And according to this clause, 18%, I have filed an application, an order was passed for securing 10 crores. It has not yet been paid.
Okay.
So this is as far as my claims are concerned.
Yes.
I have made my submissions. First of all, I have made my submissions against their claims, which have been admitted. I have accepted only one claim. My lord, I think the court will rise at 3:30, I believe.
Yes.
So on the next day, my lord, I'll just take a few minutes to state what I have submitted. And then your lordship wanted me to make my submissions in respect of the judgment delivered by the Constitution bench about the modification of the award and all this. I'll make a little submission on that.
No, you made the submission on reply. That would be the law point. Okay, to come on the law point on reply. Let them finish.
So as on date, my lord, what I have submitted, I'll just recapitulate. Yes, sir. अरे क्या कि हम सबमिशन किया है सर. Anyway, in short, I'll explain, my lord. I have given a preamble of this. I have explained what are the claims. I have stated what are the claims admitted. I have stated what are the claims not admitted.
You admitted the phrase claim only or nothing more.
Nothing else. And about my claims, my lord, I will have to make a small submissions because first of all, I have made my submissions in respect of their counterclaims. Then I have made my this. And then I'll make a little submission in respect of my claims which have been admitted. Like I am entitled for chargeable area, what is there? I have explained. Then I am entitled for license fee from the month of February 2008, my lord. Few points are there.
Yes.
On the next day, I'll just complete it.
No, not necessarily. You have already argumented. You may write and detail.
Okay, recapitulate, my lord. Kindly give me some 10-15 minutes. I'll explain everything.
No. It is better. Let them start fast. Let them start fast.
As your lordship.
In your reply, you are the chance to argue on the point of law as well as some point of fact if you want to submit.
To the best of my ability, I have made my submissions.
Yes.
If there be any query from your lordship,
Let them submit first. Let them submit first. Thereafter, the query will raise on both of you. Argument on behalf of Mr. Surana concludes. Let the matter be fixed for argument on behalf of the respondents.
Your Lordship, in this regard, may I pray for a 4 weeks time at least to prepare for the reply?
Why reply? You have to start the reply.
Yes.
What for the preparation?
Not
4 weeks. Not 4 weeks. I will not be there for 2 weeks. Thereafter, I will in the July first 2 weeks, I will not there. I will be circuit bench. Thereafter, in the 3rd week, that is on 17th.
Just may I just
17th at 2 p.m.
You've got the 4 weeks. You've got the 4 weeks.
18th of
Yes,
July?
18th can be. 17th or 18th?
Great for you.
18th.
18th.
Just right. 18th কিছু রেখেছি কি রেখেছি কোর্ট অ্যাপ্লিকেশন যেটা ফাইল হলো আচ্ছা ওটা কবে আছে 18th, very good. Let go 18th. 18th.
Here, grateful, your lordship.
Let the matter at 2 p.m. 18th, July 18th.
And may not,
I would fix the matter in the first week of July. I will not be there. I will be circuit.
and may not, as for this execution is concerned, when it can be heard, may not, now this 34 is over, at least from my side. So once their submission is over, then
I wanted some report. They have must have prepared some report
by 27th,
next week. Next. Okay, next Friday it was fixed. Next Friday it was fixed.
can that matter be heard, my lord, on that?
Let them submit a report. They have not denied your the point of.
No, I have inquired from the registrar's office. They have received that money, and in terms of lordship's order, they have
deposited.
They have invested in a fixed deposit.
Yes,
and
fixed
that reply
deposit,
will be-
auto renewable fixed deposit.
So what I wanted to humbly submit that, can I place my arguments in respect of that execution petition also, my lord? Now this 34 from my side is over.
No, no, let them complete 34 first. That will be better. Okay.
Grateful, your lord.